Tatiana?
Yep. We are now live and recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel today are Justice William Meade and Justice Peter Rubin. We will be the panel for all 6 cases being argued today. We will take a break after the third case of about 15 minutes, but the first 3 cases are all criminal matters. The first of them is case number 2020 P742, the Commonwealth versus Hector Garcia. You may begin.
Thank you, Justice Green. What if the Commonwealth is right? What if the Commonwealth is right when they argue that when the police got an equivocal identification of Mr. Garcia, it was absolutely 100% okay to dress him up in clothing that had been described by one of the victims as having been the clothing of the perpetrator and try again? That was okay. What if the Commonwealth is right?
I'm sorry, who said that he was dressed up?
This was the description of the proceeding that happened during the trial. It was also made part of the record in the police report that the person is Brown a man or a woman? Well, whatever. Brown does not testify that anything was placed on Mr. Garcia. She saw him right away, and she saw the shirt as well hanging off him because he was handcuffed. She didn't say he was dressed up. The defendant himself doesn't say anyone. The defendant himself doesn't say anyone put a shirt on him. Mr. Green said that. Mr. Green said that they put a hat on Mr. Garcia right, because he said, "I'm not really sure that's him. My guy was wearing a hat." So maybe that's okay, right?
The perpetrator was wearing the hat.
Yeah, that's how he framed it. The guy I saw was wearing a hat. And the Commonwealth argues that that's not problematic. Or if it is, that it's still not it wouldn't have been a reason to suppress the identification. What if they're right? I guess I just want the court to sit with that for a minute. If that's okay, they're going to do it. They're going to do it over and over and over and over again. And you're going to see them repeatedly relying on Commonwealth versus Garcia for it is okay to get an equivocal response at a show up, change the appearance of the defendant in some way, a way that's known to produce more identifications, including more false positives, give it another go. And if that is challenged, it would still be fine, right? That's going to happen.
Attorney, excuse me for interrupting. I don't, although obviously we haven't all deliberated about it, I'm willing to say that I don't think in general dressing someone up like the suspect would be okay. The problem I'm having with this entire argument is that I'm not sure why we're talking about it. I don't see how it can be a prejudicial error. The defendant testifies, yeah, I was in the CVS. Yeah, I'm the guy in that video, the one with the same neck tattoo that I have. The dispute here, it seems to me, is about what happened at the cash register. The defendant's version of events is, I was in there, I went up, the cashier, I didn't threaten or rob the cashier. We had some kind of dispute, and she said she was going to call the police, which quite apparently she did. So why are we talking about these identifications when it's uncontested that he was in the store? And he, not just in the store, but the person shown on the video and someone who had an altercation with the cashier on whom she called the police.
Because he did not identify himself as the person who had been in the store and explained his presence until after the identifications had made it into record at his trial. So that was him
trying to figure out a way to deal with the fact that this incredibly prejudicial information that should have been
Do you
stressed.
have an affidavit from trial counsel indicating that? I mean, there is a video that shows him in the store, someone with the exact same neck tattoo that he has.
That was a description of the video, and this goes to whether the description of the video.
Yeah, well, I want to keep these issues separate for analytical reasons. There is a video that went in. It's just the front door video. Is there any dispute that the person shown in that video is the defendant? I thought there was not. And if there wasn't, then he was in the store. So it just seems like if error, harmless to me. Maybe
You are correct. Oh, sorry.
Mm-hmm.
I couldn't see you. I have a little screen, so I couldn't see you. I couldn't tell when you were. You are correct, Justice, that this particular trial attorney did not raise an identification challenge. And that certainly affected how the defendant testified. That was part of the error. So I want to go back to whether that video was, it was recognizably him. The video, as described by the expert who reviewed it, who was the person who had tried to recover more of it, and who wasn't allowed access to the CVS matters before they were deleted. It's too grainy to tell. It's this little grainy front store thing of someone choppily walking in. The video of the close-up where you would see something like a neck tattoo is the video that that either was deleted accidentally or was deleted by the two witnesses. And again, that never got litigated because again, that wasn't challenged either by this attorney, the destruction of that video.
Do we have the video that was entered into evidence? Do we have that? Can we look at it?
I don't think I mailed it in. It is part of the record in the trial court. I don't know if it was transmitted up to the appeals court. I don't think it was disputed that the video of the front door, which is all you saw, was too grainy to make an identification from.
How can we determine that this was ineffective assistance of counsel to not challenge the identification and thus not to have the defendant take the stand? And I mean, it's sort of hypothesis on hypothesis. And unless I'm mistaken, there is no affidavit from trial counsel explaining why he or she didn't take these steps. And one reason not to take them might have been, some of them maybe don't make any sense, but one reason not to challenge the identifications might have been, well, they had a video and no one was going to say that's not him on the video.
Well, Justice, there's two different questions there. One is, was anybody saying that the only surviving portion of the video identified him clearly? And I don't think anyone said that.
I am talking about the surviving portion of the video that everyone could look at. I thought it was undisputed that it showed him.
By undisputed, if you mean did trial counsel dispute it, then no, trial counsel disputed nothing. If you mean did trial counsel dispute it as a tactical decision that made sense, I was unable, and I put an affidavit in there to get any cooperation from trial counsel. And the remedy for that was a hearing at which I could subpoena him.
Yes.
And I asked for that repeatedly. And this was impossible to get. I could not get a hearing because the lower court found that the affidavits I had weren't enough to get a hearing where I could force trial counsel to participate in this process.
I have a couple questions about things you put in your brief. You said the record indicates that the shirt did not belong to him, but you don't cite to the record. And then later you say, you're in speaking about the expert psychologist explained how dressing someone up makes it more suggestive, but you don't cite to the record there either. And then there's the last question I have was Anna Thomas, the affidavit she submitted, was that submitted in support of the motion for new trial, or was that just part of your proposed witness list for the evidentiary hearing?
No, that was submitted as part of the motion for new trial. I had asked for a hearing at which she could testify, summarizing her summarizing what she would say when the court denied it. I got permission to do
Okay.
an affidavit, and that affidavit was part of the
As to
record.
the other issues, it's helpful to the court when you tell us that the record does or doesn't indicate something, and then you don't bother citing to the record.
I apologize.
You should look at Rule 16A9, because arguments not supported by the record are waived.
I apologize if the citation is missing. I'm looking through the my reply brief now to see where that might have been, so that I
It was
can
not in your
remedy
reply
it
brief. It was in your opening brief.
in the opening brief. I know that Ayanna Thomas had mentioned the. I'm going through I can give the citations now, and I apologize for that oversight.
Well, let's start with, you said the shirt didn't belong to him. Where does that come from?
I don't think it was that the shirt clearly didn't belong to him. It was that
Why did
there's
you
no
write that in
evidence
your
the
brief?
shirt did.
Why did you write that in your brief?
Because the police had put the shirt on him after the police put the shirt on him after Mr. Brown was testifying. I'm sorry, after Mr. Brown did Mr. Green did the identification, and before Ms.
The
Brown.
police officers didn't testify to that. They said they couldn't find the shirt.
We
Brown
know
said the
that
shirt was already on him.
Brown said the shirt was on him, and Green said he was in a tank top, and he was
Right.
handcuffed the whole time. So we know, and the police said they couldn't find the shirt. So someone put a shirt on him between those two. It couldn't have been him.
We don't know who was mistaken, right? Obviously, someone is mistaken. I don't know how we can figure out who. Maybe we should draw the inference in favor of the defendant. I'm not sure.
The defendant testified that they didn't put the shirt on him. The defendant said he used the shirt because he had a head wound. He used it as some sort of bandage. Or before we run out of time, I have a question on the videotape and the remedy that you think should have occurred. What was your preliminary showing that the lost tapes were exculpatory? And keep in mind that this has to be based on concrete evidence to make that showing, because the judge found, as you know, that you made no showing whatsoever.
Well, the tapes were gone. The concrete showing was simply the affidavit from the only concrete showing was the affidavit from the expert who tried to get access during this time and who was repeatedly rebuffed.
But that doesn't
It goes
reveal
to
anything. It doesn't reveal anything exculpatory about the content. And then that is to be measured against the witnesses who did watch the tapes, who all said the contents were inculpatory.
The issue here is that the conduct, and again, this is simply what the video expert reported, that the people who were responsible for the video, who were responsible for keeping it safe, and who also reported what they saw, were reporting things about the video and how it was stored and who would have had it that were not only demonstrably untrue, but that in her experience of people who do loss prevention and people who work in retail, everyone would have known were untrue.
Okay.
That's it.
We've glossed over my initial question because you're into the culpability for the loss of the tape, which the judge found CVS was negligent, not the Commonwealth. So back to, before we even get there, you have to fulfill an initial burden to show that there was a real possibility that there was exculpatory evidence on there, and that showing has to be made with concrete evidence, not speculation or supposition.
All I have is consciousness of guilt by the people who destroyed it. It's necessarily circumstantial. There's nothing concrete. I don't have the tape. My client never saw the tape. No one ever saw the tape on our side.
Do you have a case that stands for the proposition that when evidence like this is lost, a witness, not dismissal, because that seems, if there's no culpability, that seems like strong medicine, that maybe testimony about lost evidence is not going to be allowed because the ability to cross-examine about it has been eliminated or something? Is there any case law? I didn't see any case law about loss of evidence by third parties for which the Commonwealth is not going to be held culpable, but as a matter of fairness, there's going to be some restriction put on it. Are there any cases like that?
No, I didn't find any cases that were squarely on point for that. But I also did not find cases that.
Is there a confrontation clause problem?
Yes, there is a confrontation clause problem. There's a fairness issue.
You didn't raise it here though, right?
I think I did not raise the confrontation clause problem. I think I raised only the fundamental fairness issue. And actually, going back, I think I said yes to you because I wanted that to be true. The problem with there being a confrontation clause problem in this case is that the witnesses who were purportedly lying
testified and were available for cross-examination.
They survived and were available for cross-examination.
Right.
So it's not a formal Sixth Amendment confrontation clause issue because theoretically the expert could have come on and said they're lying and they're making this up.
I think we're going to have to do that there. We have the point.
Massachusetts is a little looser in that, but there's not a formal federal one, and the due process argument is certainly much stronger.
Thank you.
This is a fundamental fairness issue, and there is no requirement.
Attorney Goldblatt, that your time has come to an end. We'll hear from the Commonwealth. Thank you.
Thank you. May it please the court, David Shepard Breck on behalf of the Commonwealth. As the panel has rightly pointed out, there was no evidence that this video was in any way exculpatory. I want to address the video that was admitted into evidence. What I will say is that it is not the greatest quality video, but the defendant has a very distinctive neck tattoo, and you can see that on the video. And so perhaps we could have I can work with defense counsel. We can get that sent up to the court because I think that at trial, it wasn't disputed that that was him on that video, given the fact that, he was wearing, as described, the hat, the button-down shirt, the jeans and the boots. And he did have, you can see there is, I think it's on this side, a neck tattoo that's fairly distinctive.
Can I ask a follow-up on Justice Meade's questions at the end there about the lost evidence? The defendant testifies that that isn't what happened, right? That's his sworn testimony. Right. I didn't flash a gun. I didn't take any money. Why isn't that sufficient to raise an issue about whether the videotape would have been exculpatory or inculpatory, since we don't have the video?
I think because there were a number of other witnesses who saw the video testify.
No, I understand that they may be more credible. I get that. But I'm talking about raising an issue sufficient that we have to look at the question of, was it fair, if that's the question, to let people testify about a piece of evidence that's lost and that the defendant has never seen, nor has counsel. And so it's obviously, I don't know if it's a confrontation clause violation. The witness is the camera in a way, not these people. And they're testifying about the contents of the video about which he really can't, he can't do anything. They say it shows X and the end, right? I mean, what are you going to ask him? Did you look carefully? Oh yeah, I looked carefully. There's not much left if you don't have the videotape. And the videotape may of course be exactly what they testified, but I'm just asking about the fairness of it.
So in terms of raising the issue, the motion judge, motion judge was also the trial judge, was able to view the defendant testifying, and he found that there was no credible evidence, that raised the issue that it was exculpatory. So I think because of, if we were dealing with a situation where he had been someone other than the trial judge, I think that would be a stronger or more problematic issue for the Commonwealth.
How many people saw the video before it was deleted or destroyed or whatever?
It was Sergeant Miller testified that he saw it. Green testified that he saw it. Detective Rivera also testified that he saw it. So there were 3 witnesses.
So 2 police officers and the manager of the store, is that what you mean?
That's correct. And even if the court gets to the issue of whether or not, say that you assume that the defendant has made his initial showing, that the balancing test just doesn't require suppression of the evidence, dismissal of the case, any of those remedies, because the Commonwealth was not at fault for the loss at all. And even the defendant's arguments about how CVS is, that they destroyed the video or what have you, that's still not the Commonwealth's fault. And there was the motion judge, Judge McDonough, had 2 hearings. We took testimony of Mark Vieira, who's the CVS representative. He considered the affidavit of Lindsay Hawk, who's the defendant's expert. And he said, I'm not holding CVS in contempt. There's no basis for me to do that.
What is the best case you have for the use in a criminal trial of a witness's observation of subsequently destroyed evidence? The Commonwealth is not culpable and it's allowed to go forward. Do you have, I asked your sister if she had a case the other way. Do you have a case going that way?
Well, it's certainly discussed in Commonwealth versus Mias, where they're talking about, there had been a witness who saw the video and testified. I think that's more on the issue of whether or not it was exculpatory. So yeah, I would say that's a certainly a good case where they were allowed to testify as to, or that the defendant hadn't reached his initial burden.
We certainly allow testimony as a matter of routine of percipient observations of which there is no video or other record, right?
Yeah, that's correct. I mean, it happens all the time where you have witnesses who testify to.
What's different here is that there was, in theory, some independent, objective, corroborative record that could have been available and then was lost, and then that's why we get to the question of culpability.
Well, right, and again, I think the question of culpability is clearly it was CVS who was at fault, not the Commonwealth. And when you at the end of the balancing test, you also have to look at the materiality of the evidence. And given again the overwhelming evidence that the video showed exactly what Brown described happening during the robbery, according to Sergeant Miller, Detective Rivera, and Green, the manager, there's not prejudice to the defendant based on the fact that all the evidence supports the fact that the video was highly inculpatory.
Do you want to say anything about the identification issue or anything else?
I can briefly address the identification issue just to say on page 34 of the Commonwealth's brief, I did say that Brown had already made an unequivocal identification. That was an error. Should have said that Green had already made an unequivocal identification. And so Green's initial ID, the defendant says, well, he said he was 80% sure. What happened was the prosecutor asked Green, what did you tell the police as to how sure you were? And he said, I think I said 80%. And when she then showed him a document, refreshed his recollection, he said, okay, I actually told them I was between 85 and 95% sure. So that's his initial identification. So I would suggest that that's unequivocal. You don't have the hedging the defendant cites to Yang, where 80% plus it's the second time through the photo array, plus the witness sort of says these things, it's something about his hair. Here you have a witness who says, look, 85, 95% sure that's the guy.
Did he say 95%? before the hat was put on him?
Before the hat was put on, he said, 85 to 95% sure.
And then when he got the hat,
95% sure.
95. Where did the hat come from?
The hat was the defendant's, and I think that's in the record. As to what happened with the shirt, it's unclear. But that was the defendant's hat. It was actually, I believe, it was admitted as an exhibit at trial, and I think the defendant looked at it and said, "Yeah, that was my hat." So the hat was definitely his.
I assume the Commonwealth's position is not that you're allowed to dress up suspects as the perpetrator for purposes of doing identifications, right?
No. And as I said, perhaps it wasn't probably the best practice, but that doesn't necessarily mean it should be.
But it might be not just not the best. I assume if you were doing a lineup and you had in the evidence room the suit that the person was wearing during the murder, you wouldn't or couldn't force one of the people in the lineup to put on the suit for purposes of doing the identification, right?
Right. No, right. I agree that it was not a great idea. I don't think that they were really sort of thinking that through. But what you have at the end of the day is, Brown is 100% sure right off the bat. I mean, yes, he is wearing the hat. But you also, again, you have the video.
I understand what you're saying about the materiality of that increased certainty, if there is increased certainty or whatever. But let me also ask you about the shirt, because of course the testimony is utterly inconsistent. He says he's wearing the shirt the whole time. Green says he was in a t-shirt. The police say we never found the shirt. Brown says he was wearing the shirt. So are we supposed to assume he was wearing the shirt, wasn't wearing the shirt? For purposes of this, if there's no fact finding, should we just draw every inference in favor of the defendant and say it was draped over him between the green and the brown? Or what are we supposed to do with this kind of testimony?
Yeah, so, right. There is definitely some inconsistencies. The police said they never found a shirt. Brown said, she said it wasn't draped over him. I think she said it was falling off of him. But right, I think that regardless of what exactly happened, ID just wasn't an issue at trial. And so I would focus on the prejudice argument that it wasn't an issue at trial. It wasn't reasonably an issue at trial, again, because of the surveillance video and the fact that, he has this very distinctive neck tattoo, which can be seen on the video.
His defense is, I'm not the robber, so I don't see how you can say ID isn't an issue.
His defense was, that no one was robbed, that I went up to her. I had an altercation with both Green and Brown, and I walked out of the store, and he said, "Yeah, that's me walking in. That's me leaving." So, it just wasn't, and I don't think it was reasonably an issue that he wasn't in the CBS that night for the identification issue.
Anything else?
If the court has no more questions, I'll rest on my brief.
No.
Seeing none, that will conclude the argument in this case. Thank you. I will call the case and we will begin from there.
All right, we are live and recording.
The next case on our list for hearing this morning is case number 2020-P445.
We are live and recording.
Does one of you have the YouTube on? Morning is case number 2020-P445.
We are live and recording.
Does one of you have the YouTube on? Morning is case number 2020-P445.
We are live and recording.
Okay. Let's try again. Okay, the next case is case number 2020-P445, Joseph S. Van Loo versus the Commonwealth of Massachusetts. Attorney Gauthier?
Yes, Your Honor. Thank you. May it please the court. My name is Attorney Edward Gauthier. I'm appearing today on behalf of the plaintiff appellant Joseph Van Loo. Mr. Van Loo was before a jury in 2019 who found that he remains a sexually dangerous person. We've raised an issue regarding the admission of statistics, and I'd first like to address the requested relief in the standard of review. The first objection we've raised is to Joseph Cloud's testimony on cross that only 1 to 2% of sex offenders who've been convicted are so dangerous as they require civil commitment. There was an objection to that. The standard of review would be by whether there's prejudicial error. And there was testimony by Dr. Rouse-Weir, a expert for the Commonwealth, regarding her personal findings when she does evaluations regarding how often she finds people sexually dangerous at the initial stage, the QE or qualified examiner stage, and at the discharge stage. There was no objection that would be under substantial risk standard. I would point out, however, Your Honor, that although we are required in all cases to ask for a new trial, Mr. Van Loo already has a new Section 9 trial scheduled in the next few months. So whether this court orders a new trial because it finds that the statistical information met the standard of review, regardless, by the time this court makes its decision and by the time the SJC looks at it for further appellate review, and I assume that regardless of the losing party, there will be further appellate review, Mr. Van Loo will have his trial by that point.
Are you suggesting then that the present appeal is moot?
Absolutely not, Your Honor. And I suggest it's not moot because these are issues involving evidence that's likely to recur not only in this case, but in other cases. And I would point out to Your Honor, in my experience looking at these Section 9 appeals, most of them are decided by the appeals court and the SJC almost simultaneously, or sometimes even before the new Section 9 trial happens. And in so many of these cases, the fact that they receive a new trial before this court can decide legal issues often moots a lot of the issues, especially those that are not likely to recur. But these are issues, the introduction of these statistical information is something that could very well.
Well, the case isn't moot. So, right, there has been no new hearing. Right now, it's a live case.
Yes.
If we can decide it before a few months from now, it'll still be a live case.
It will still be.
Someone will let us know if it's moot.
We would do that. However, we would argue that it would not be moot even if we had the new trial.
Got that.
Right. And no one is saying it is. So let's get on with the argument.
All right. So in this case, there were a number of statistics that were admitted, and these statistics are admitted in many cases. First is the static 9.9R. All of the experts, the Commonwealth experts and the defense experts, all testified that my client poses a 5.6% risk of recidivism for conviction within 5 years of being released. We don't take any objection with the introduction of that. We do take objection, however, with evidence admitted by the Commonwealth regarding how dangerous my client is simply because he was previously found to be a sexually dangerous person by introducing evidence that only 1 to 2%.
But that evidence wasn't used for anything. It's true, there's a question and an answer, but it's not used in the trial. No one ever mentions it again, right?
Well, it was brought out on cross-examination by Commonwealth counsel.
It just doesn't seem like, I mean, I'm not sure what it proves. I mean, maybe it proves something, maybe it proves nothing, but well, it just doesn't seem like sort of where the center of gravity goes in this case.
We argue that the Commonwealth argues that this was an overwhelming case for the Commonwealth. We argue that this was a very close case. The evidence that only 1 to 2% of individuals are subject to civil commitment goes to showing that simply by virtue of the fact that my client was considered for civil commitment in the past and was subject to civil commitment in the past, he is automatically one of the 1 to 2% most dangerous sex offenders that there are in the system. Although it wasn't referenced in a closing argument, that's a significant piece of information. These jurors now know that 98 to 99% of people who have been convicted of sex offenses are never brought to a trial to determine whether they are sexually dangerous. It is only the
Why wouldn't the jury hearing this think, oh my goodness, it's really difficult to establish someone's sexually dangerous. So that makes our task very much harder than anything the judge is going to tell us, because it's very rare.
It is very rare, but again, they do know that a jury has already found that he is sexually dangerous.
Because that's an element of the crime. Of course, they know that.
So they've already been told that only 1 to 2% of sex offenders are so dangerous as to require commitment. And in fact, a jury sitting in the same position they were in found him to be sexually dangerous. So they already know coming in.
Well, that second part, they know anyway, right? That may sway them. That second part seems like the bigger deal to me. I don't know. This guy has been found sexually dangerous before. We're asking you to let this sexually dangerous person out because we say he's not sexually dangerous anymore. That seems like it seems inherent, unfortunately. I'm
sorry.
No, go ahead.
And now he's 5 years older, right?
He was found sexually dangerous in 2009. He petitioned in 2016 for release. In 2015, he was actually found to still be sexually dangerous by his own 2 independent examiners, which is something the jury also heard. So the jury heard that as of 2015, even the 2 independent examiners commissioned by my client's counsel found him to remain a sexually dangerous person.
And there's no difficulty with the admission of that evidence, right?
It wasn't objected to.
Well, I mean, that's a different question. You're not claiming that it was improper to admit that evidence.
No, I actually think that was probably a good strategic choice by counsel because it showed that the experts for my client weren't just saying that he was not sexually dangerous because they were paid. But
quite just independently of whether it was a wise strategic choice, if it had been offered by the Commonwealth, there would have been no grounds to exclude it, right?
That I think is a bigger question. Although the statute for the admission of evidence in a sexually dangerous person Section 9 trial is extraordinarily broad, right. And it essentially encompasses.
And we don't need to answer. I didn't mean to sidetrack us by asking that question. My point is simply that we've got a mountain of evidence that's coming in. As you observed, this question and answer was not touched upon in the closing argument. And the judge's instructions gave the jury a clear sense of how they were to weigh and consider the evidence that was admitted, right?
We make no objection with the instructions that were given to the jury.
Your observation is actually a good segue into the second piece of this case. You're glad, you say, I'm not like holding you to this, like this is the case, but you're glad, you say, that the jury could hear that independent examiners sometimes find people sexually dangerous and no longer find this one sexually dangerous. But you're objecting, as I understand it, to evidence that 40% of the time or 60% of the time or whatever percent of the time it is, that the government's experts find people not to be sexually dangerous. Is that right?
That's because the testimony regarding Dr. Rao's we're finding people sexually dangerous or not sexually dangerous involves people that aren't my client. I believe that it was a good strategic choice for counsel in this case to point out that, yes, in 2015, my client was sexually dangerous. However, he isn't now. It gives a lot of credibility.
I see. So let me ask you about this evidence. What is the problem exactly with asking these? The complaint is about cross-examination of your people, or it's about the direct examination of the Commonwealth's QEs, or both?
It's actually 2 objections. One is the cross-examination of the clients, the plaintiff's expert regarding 1 to 2% are sexually dangerous. The second was direct examination of the Commonwealth's witness regarding how often she finds people sexually dangerous.
And is the reason for that the rules of evidence, that this is bolstering credibility when it hasn't yet been attacked? Something about maybe character for truthfulness or something? I guess I just don't understand what the objection is.
Well, the objection in the first instance is that it's not relevant. Whether a particular qualified examiner who works for the Commonwealth finds a person dangerous 1% of the time, 10% of the time, 50% of the time, doesn't really impact any of the elements that the Commonwealth has to prove. It doesn't.
Credibility is always, credibility of the witness is always relevant, right? That's always a material question. And I assume you would be saying that if the QEs found it 100% of the time, that would be relevant, right? I mean, then you'd be saying, I assume, I don't know about you personally, but then one might say, oh, this is a sham. QEs are a sham. They say it 100% of the time. Right?
If a qualified examiner found 100% of the time, then it could be attacked as simply an employee of the state making a predetermined determination.
Mr. Garcia, the problem I have with his argument is that it strikes me as being fairly routine territory for impeachment of an expert witness in civil trials. I mean, in a med mal case, it's routine for an expert to be asked how many times you testify for plaintiffs and how many times you testify for defendants. Isn't that the same thing that we're talking about here?
I would say that yes, if an expert were attacked on cross-examination and impeached with evidence that they only testify for one side or the other, then maybe that's relevant. But in this case, we have on direct examination, bolstering of an expert witness's testimony through statistical evidence that does not essentially bear on the facts that the jury has to find.
And what does that violate exactly?
Well, the argument we're making is that it's simply not relevant to the jury.
Why would it be relevant on cross-examination but not on direct?
Well, if hypothetically, if a qualified examiner or independent evaluator found 100% of the time, then that would be relevant on cross-examination to show that they only find one way.
That goes to weight. I mean,
yeah, 92% might be relevant too, or 87, right?
I mean, it shows what it shows, and then the question is, what do you do with it on cross? But I mean, the question of whether it's relevant, it seems to me, is different. I thought I heard you complaining about bolstering prior to attack, and I'm not sure I understand why that would be problematic in this setting, but that is not based simply on relevance.
No, that wouldn't be based simply on relevance. We're just trying to get the court to consider the use of statistical information that really doesn't bear on an offender's likelihood of reoffending.
But you want to be able to use it on cross if it's favorable, right?
Well, I don't think.
I mean, it would be bad to not let you use it on cross, right?
Well, that's only in the hypothetical where you have one side where 100% of the time.
But I have to say, I assume you brought out, this has always concerned me, that all of these examiners work for a vendor who has to get DOC to hire it over and over again. And so there is, in fact, some basis maybe for thinking there is bias involved. I assume that was all in the record, right?
There was some, there's always in the record, of course, some argument about how independent examiners are only hired by plaintiffs. They never work for the state, so they can't.
QEs, I mean, challenging QEs on the ground that they work for this vendor that has a contract with DOC, and DOC isn't gonna, if their vendor is constantly saying people should be released, they may not hire them, right?
That's always part of the argument on credibility, on both sides, though.
Right.
Sure.
Both sides argue that the experts for the other side can't be believed because they are essentially, they work for one side and they don't work for the other.
And this is all just a part of that.
That's always a part of that, yes.
Right. All right. I see that your time's coming to an end. Unless there are other questions from the panel, I think we're gonna have to leave it here.
Thank you, Your Honor.
Okay. Attorney Murray. Take yourself off mute, please.
Mute is on, yeah.
I'll try that again. Good
Okay.
morning, Your Honors. Mary Murray for the Commonwealth. The petitioner has given the court no cause to disturb the jury's verdict here. Neither of the issues that he raises warrants disturbing the verdict, and for that reason, this court should affirm. I'll take the last issue that the petitioner discussed first. As Justice Rubin mentioned, there are frequently attacks on the qualified examiners and to whether or not they are the hired guns, although that term is not often used directly in court, but that's the gist of it. As the SJC reminded us in Chapman in 2019, the qualified examiners serve as though appointed by the court, not retained by, paid by, or beholden to any party. Their reports are made available to either side, regardless of the opinion, and filed with the court. Now, in this case, the jury was fully informed of how, through Dr. Rousweir's testimony, how they're hired. They're appointed by the Commissioner of Correction, which is a matter of statute, and how they're selected on a particular case. And Dr. Rousweir testified about that on direct. The Commonwealth anticipated at the trial that there would be cross-examination about how they get paid and an attack on their credibility because of that designation and the contract with the Department of Correction. So on direct examination, the Commonwealth asked about it without objection, and that was entirely proper. In fact, not only was there no objection, but Mr. Watson, a very experienced attorney representing the petitioner, followed a similar course with his own expert, with both of them, Dr. Bard and Dr. Plod, his retained experts. So there was certainly, if he had objected, I would have waited, the Commonwealth would have waited until redirect. And that was entirely proper. Turning to the other.
I think maybe I'm missing a little bit of what's buried in what you're saying. The reason it was proper on direct, you're saying it ought to have been saved for redirect, but there was no examination, or can you bolster your witness's credibility before it's attacked on cross, or it was raised? I'm just confused. Is there any issue about where this evidence went in?
There was no objection at the trial. So it is relevant to establishing credibility, as the Chief Justice just remarked. Witnesses get asked all the time how many times they testify for either side. But
is that about character for truthfulness? Maybe this isn't raised here, and can that be brought in? Can that be brought in on direct? I'm not sure that's presented here, but that's my question, I guess.
It wasn't offered for character for truthfulness. It was establishing what the witness does, what the witness's roles as qualified examiners are, that they are not retained by either side, unlike Dr. Barnes.
No. I mean, first of all, they are actually retained by DOC. So, okay, but it's different to say you're not retained by either side, so you have no bias, and to say, and in fact, maybe it's the same. I don't know. And in fact,
I understand it to be going to bias and in an anticipatory effort to deflate any suggestion of bias.
That's exactly what it was. And just to be clear, the qualified DOC is not a party to this proceeding. The Commonwealth is a party.
Okay. But DOC is part. DOC. Okay. I mean, this is not in this case, but yes, DOC is part of the Commonwealth. They hire these qualified examiners. Maybe they're neutral. I don't know. We don't know. But whatever. This is all before the jury. It's not our call anyway. The jury can sort this out.
That's right. And the evidence came in without objection. Had there been an objection after the attack on credibility in the cross, it would have come up at that time properly. So any objection is to the timing. But when you're dealing with experienced counsel, there's something to be said for letting counsel try their case, and the petitioner chose not to object, undoubtedly because it would have come up on redirect. So Turning to the next issue, which is the percentage of prisoners who are adjudicated to be sexually dangerous, there was no error in the admission of that evidence because it directly countered the petitioner's reliance on statistics. The petitioner was trying to wrap himself, his attorney was trying to wrap him in the protective cloak of statistics about general populations of sex offenders. SDPs are not general populations. And the repeated effort was, well, he's at 5.6% risk. The testimony, even from Dr. Bard, was that is not his risk. That's the risk of a general sample of sex offenders. And the Commonwealth was educating the jury throughout, through direct, redirect, cross-examination, that SDPs and Mr. Van Loo in particular are different. And there was ample evidence on that point. And the trial judge did not err by admitting it. And recall that this came in on the cross of the sixth and final expert witness who testified. The judge was well positioned to understand the relevance of the statistics and explaining the variations in the samples that were considered, the small samples, the sample sizes, where they come from, the follow-up time, and the Commonwealth throughout direct and cross educated the jury about the limitations of those statistics. And that was entirely proper. And this court, in fact, just last summer, in one of its Sex Offender Registry Board cases, noted that the SDPs are a particularly menacing subset of sex offenders. In Doe, one of the many Doe cases, 97 Mass App Court 564, the pin site is 569. SDPs are not an ordinary subset, and there was statistical evidence brought in about a study of released SDPs that showed that they reoffend at markedly higher rates, or caught, I should say, reoffending, detected reoffending and recharged at markedly higher rates. And it was entirely proper to do that when the petitioner is the one who introduced the statistics in the first instance. And so unless the court has any questions, the Commonwealth would be content to rest on its brief.
Seeing none, thank you. The argument is concluded and the case of Tube Stream is open. I will call the case and you may begin.
All right, we are live and recording.
The next case on our list is case number 2019 P1548, Commonwealth versus a juvenile. This case is impounded. I'll remind counsel to refrain from referring to any of the impounded material. And just as an alert to those who may be watching on YouTube, we will take a 15-minute recess following the conclusion of the argument in this case before proceeding with the balance of our case. Attorney Alpert, you may begin. Attorney Alpert, you may begin your argument.
Thank you, Your Honor. Good morning and may it please the court. Caroline Alpert for the juvenile. The court added a probation condition to cooperate and comply with DYS conditions of release. And there are three independent reasons why this addition was illegal. First, the court did not have authority to add this condition. Second, it was unconstitutionally vague. And third, it violated the separation of powers. Before I get to the legal arguments, I thought it'd be helpful to clarify the sentence.
Attorney Alpert, this wasn't preserved by an objection when the added condition was put in, right?
It was not objected to at the time that it was initially imposed, but it was objected at the time that it was enforced at the violation hearing, which is sufficient for preservation purposes. This was a similar procedure to the case of Commonwealth versus Lally, where there was not an objection at the time that the condition was imposed, but at the violation hearing objected to, that was directly appealed, and there was not a preservation issue. And what's important for preservation is to particular issue and correct it, which it did in this case. It was raised at the violation hearing that the condition was improperly added, and so the court had the opportunity to correct it at that time, find him not in violation, and remove that condition, but it did not.
I gather that the judge's reference when imposing the condition to the DYS conditions of liberty, I take it that that reference is something of a term of art in this field?
So yes, they are referencing DYS grants of conditional liberty. So the way that that works is when a juvenile is committed to DYS, DYS then has a procedure by which they determine how much time the juvenile will be spending in secure confinement, and then they are generally released to the community after that for some period of time, and DYS is able to determine what the conditions of that release is. It's essentially the same as adult parole. And so
how are those reflected? How are those memorialized?
So my understanding from the regulations is that there is a process that DYS goes through where they have a treatment team meeting and they discuss with the juvenile and other interested parties. And it does appear from the regulations that there is a document that gets signed. However, I think what's important for this court to know as well is that DYS has a very fluid and flexible way with which they change those conditions. And so it's a much less stringent way to change those terms as opposed to the way the court would have to change probation conditions.
Well, before we delve into what may happen in some cases, I guess I have a threshold question. Was that agreement entered into here?
It was not, Your Honor, and you do raise an important point as well, that the record doesn't indicate whatsoever what was communicated to the juvenile and what the terms were. So based on the record—
Wait a minute. There are two things embedded in what you just said, and then they may both be accurate. I understand that the record does not include the agreement.
Yes.
Does the record also include evidence that there was no agreement?
It does not include evidence that there was not an agreement. I would say that the record doesn't include anything about what happened.
I understand that, but to the extent that
at the time it was
to the extent that you are challenging the substance of those conditions, the vagueness or the process by which they were entered into, it's one thing to say that it's wholly untethered. It's another thing to have an agreement and a process that we can examine to see what the details of those conditions were and understand whether the juvenile would or would not have been fairly able to understand the limitations that were applicable.
And Your Honor, perhaps if that agreement was in the record, this would be quite a different scenario.
I understand that, but isn't that your burden to put if you're challenging the conditions? I understand that this may not go to the separation of power question and the question of whether this was an impermissible delegation. But before we get to that, if you want to establish that the incorporation of the conditions of liberty was unconstitutionally vague, we need to understand what they were, and without that in the record, it seems to me it's you haven't established a record to demonstrate entitlement to relief.
Well, Your Honor, I think what we need to look at is what was communicated at the time the condition was imposed. And at the time the condition was imposed, if probation wanted to add these conditions, if the court wanted to add those specific conditions into the record, and a way that the court could have done this properly, assuming that it followed the proper process for altering probation conditions, is that probation could have submitted the particular contract and the court could have gone through each individual terms and determined which ones were appropriate and individually tailored.
At the time that the conditions, that this additional condition was added, it was done in the context of a rather glaring gap in the original conditions, right? The change of address is one thing, but if the defendant, the juvenile goes AWOL for several days, that goes against the obvious intent and spirit of the original conditions, if not the way that they were spelled out. And so it seems to me that what the judge was attempting to do, and what everyone understood the judge was attempting to do, was to make clear to the juvenile that he was to stay at the residence to which he was assigned, and report if he was going to go somewhere else.
Your Honor, those conditions, though, in fact, were not part of the original spirit of the probation. The original, and so again, I think just to quickly clarify the sentencing scheme, which I think is helpful to answer your question. There were two charges.
I'm still at a loss. The CMR requires these conditions to be written down in clear, developmentally understandable language. Are you saying that wasn't done? Or are you saying they are, let me finish. Are you saying that was not done, or you failed to put it in the record? It was done and it's not in the record.
I'm saying we don't know whether or not it was done. And
Can I ask this question? I don't understand.
Wait, let her finish my question.
Okay.
What,
go ahead.
before you, please finish your answer.
yes, Your Honor, we don't know what those conditions were. We still don't. And I think another important point is even if the juvenile at the time that that condition was added on that day did know what those conditions were, DYS could have easily changed them the next day. And so then we're left
Well,
with
okay,
this
that's
question
that's
of
a
which of the
different issue.
actual terms the court is.
Oh, we don't
So-
have that. We don't have that in the record either.
But-
There's no indication that DYS did change them, right?
Well, so we do have the regulations which say that DYS can updates them at least every 4 months, if not more frequently. And we do also have from the May 6th hearing evidence that the case manager was pretty easily changing these conditions. Probation, when she comes back in after the lobby to the actual hearing, says, oh, I just talked to the case manager outside and he said they're going to change the curfew and they're also going to make him go to therapy. And so that's just evidence that the case manager can pretty easily change the conditions as he should be able to. DYS has a very different role here.
Yes, can I ask you, Attorney Alpert, whose burden is it to demonstrate a violation of probation?
It is the Commonwealth's burden to demonstrate.
If a probation condition is compliance with certain written conditions, can they prove that without putting them in? Whose burden is it to put into the record these conditions? Isn't it inherently vague if you don't put them in? Who knows what they are? I don't know. How would the judge below know?
I would agree, Your Honor. I would agree, Your Honor, that if probation, especially at the violation hearing, even at that point when we do have the condition of cooperate and comply with DYS, it's still actually unclear what specific term
So
he
don't we have to
violated. We don't know
reverse-
if the issue.
Don't we have to reverse? Isn't there insufficient evidence to support the finding of a probation violation if these things aren't in the record?
That would be an additional argument, Your Honor,
I
that
mean,
I
I'll
did
ask
not
your
raise.
brother about it, but I don't understand. You know, we're talking about what's at the core of the prohibition and not. We don't know what the prohibition even says. Who knows what's at its core?
I agree, Your Honor, and that goes to the heart of my vagueness issue. And I do want to raise another important point here, which is that when the juvenile was sentenced, there were two independent sentences on two different charges. And so on one charge, he was sent to DYS, committed to DYS. The court closes that case, and DYS then has purview over that supervision. Meanwhile, he's put on adult straight probation on the second case, meaning that violation of that probation carries the penalty of adult time, including state prison time. And the conditions on that were not at all similar to the types of conditions that we think we're talking about with DYS. They were very standard conditions of probation. They included the standard conditions that are on every form, such as meeting with your probation officer, not picking up any new offenses. And the only special condition ordered was a stay away, no contact with the victim in the location of the offense. So at the time of the plea, the juvenile was essentially told, you're only going to have a penalty of state prison time if you engage in this kind of serious behavior. And here we have DYS that can impose a pretty expansive scope of types of conditions that are very different from the scope of what was originally set. And so that also raises this double jeopardy issue in regards to whether the court could have added this condition, even if there was a material change in circumstances. And I realize now I also did not address materiality, which I discussed in my brief, which is that a 20-year-old not coming home for a couple nights and then coming home, I'm not saying that that's okay. And certainly that's something that DYS has the authority to supervise, penalize, revoke his liberty for, but that's not the type of behavior that warrants changing a probation condition. It's not.
I don't understand that argument. Why isn't it? He's in DYS custody till he's 21. He's not allowed to, he's out of a locked facility because of an agreement that, at least from what we can read in the record of when it was imposed, apparently included an obligation not to do that, right? How can you say it's no big deal or not a changed circumstance? It's not drug dealing, which was a big deal, I think, in one of the other cases. But I mean, maybe he should be locked up. I don't understand how that's not a changed circumstance.
And Your Honor, it's certainly behavior that DYS should supervise, and they did. I believe the record does indicate that they had a revocation hearing and did revoke his liberty. So he did go back to a secure facility within DYS's purview for that behavior, and that was appropriate. The question is he going to get state prison time for that behavior when he was told that his probation was basically, don't pick up new offenses, meet with your probation officer, and don't contact the victim. And what the record shows at the time it was imposed in November, the probation officer clearly says in the record, he's in complete compliance with his probation. He's meeting with me weekly. He hasn't picked up any new offenses. So yes, that behavior is certainly something that DYS should be addressing, but it's not something encompassed within the probation supervision that carries this adult penalty with it. I believe we discussed the vagueness issue. One other point I want to raise in regards to that, going back to the fact that DYS can very easily change its allows circumvention of all of the rules and procedures we have in court for how to change probation conditions. So as it has been discussed in this brief, there are certain legal standards that need to be met to change probation conditions. But if you put on this blanket-like expansive condition, DYS, you set the terms, then all that needs to happen in order for a term to change is for DYS to call up the juvenile and say, oh, by the way, I'm adding on a curfew. And so as a result, we're not actually going through the procedures that are clearly mandated in order to change probation conditions. And there's also not an opportunity to address whether any of these conditions implicate other constitutional issues that have been addressed in other cases, such as drug and alcohol screens, GPS, things of that sort. And finally, this leads me into the Article 30 issue here, which is that the way this condition was crafted essentially allows DYS to set the terms of the probation. The court is really delegating what those terms are, and this is quite similar to the case of Commonwealth versus Lally, where the court said treatment is deemed necessary, and then the probation officer later said, after looking at an evaluation, oh, we're going to add drug and alcohol screens. And the court said, no, you cannot do that. The judge absolutely cannot delegate its authority to anyone else to dictate the terms.
Excuse me, but that wasn't the violation, though. He was violated for not keeping DYS in the loop of where he was living, and which leads to was it for failure to give an address or failure to give a residence?
So there were two violations. The first was the cooperate and comply with DYS, and in terms of that violation, we still don't actually know what the specific violation was. Was it that he needed to get permission to stay out? Was it that he had a curfew? Was it that he had to be there every night? We don't know what the violation was for that condition. The second violation, probation violation, was failure to notify of a change of address. And there, this is a separate argument. It's just a straight sufficiency argument there, which is that there's no contest.
Michael, is it specifically address and not residence? Because there's a difference.
I believe what the violation said was a change of address, but the facts that I cite to, I think it's analogous to say that you don't have to be telling probation every time you spend a night somewhere else. The point is, what is your residence? And here, being gone for 2 nights and then returning. Oh, I'm sorry, I see my time expired. Would you like me to finish?
So you're not going to tell us what it is then? Is it residence or address?
I believe it's address. Or I'm sorry, if Your Honor will give me one moment, I can pull up.
We'll ask Mr. O'Sullivan.
The term. Change in residence, Your Honor.
Yeah.
Residence, thank you.
All right, thank you. We'll hear from the Commonwealth.
Good morning, and may it please the court, Shane O'Sullivan for the Commonwealth. With the court's permission, I'd like to start with the vagueness issue. Due process requires, and the language that's used at the starting point that I would suggest is the most important language here is, does this condition provide reasonable guidance or a definite warning? The Commonwealth would suggest that the condition to comply with the DYS agreement did provide such reasonable guidance and a definite warning.
What's
What
the
are the
agreement?
what are the terms of the DOIS agreement?
And again, Your Honor, as was noted in my sister's argument, that was not placed into the record.
So how do we know what you just said is accurate?
Well, I think we can glean it from the rest of the record. Number one, to whatever extent there's a burden at this point to produce the record.
Well, but the Commonwealth's burden at the surrender hearing was to establish that there was a violation, and in terms of vagueness, to claim that the terms were clear is hard to evaluate without the terms.
And and I would look at the what was the complained of violation of that agreement. If you look at the procedural history, this defendant was first given a notice of violation on November 1st. That's when this condition was added. He was told that it was his, leaving without permission or notice, his going AWOL, as it was described. He violates under the same conduct in January of 2019. And then now this is the third time where that same conduct is the basis for a notice of violation. So
I'm not suggesting for a moment that it would not have been possible to craft a set of conditions to make clear that that was not okay. But I don't see in our record where that is laid out.
And I think the perspective is did it give reasonable guidance to the juvenile? Did it give definite warning to the juvenile? And
did what give definite guidance?
Well, the record discloses that the juvenile at least had definite guidance as to this particular aspect of it, that leaving. What
you mean is that the discussion at the hearings, but again, I suppose it's an inference that the DYS condition of liberty agreement incorporated that condition. It would be a whole lot easier to accept that premise if we had it.
No, I agree. The better practice would have been to have admitted the agreement. However,
well, that doesn't. I mean, it is in part a question of sufficiency, at least on that topic, isn't
it? Potentially, I don't know that sufficiency has been raised here, but again, or I don't know that sufficiency was argued below by the defendant. I see, in the at least the transcript of the most recent violation, my interpretation of that is
it's argued on appeal, though. The sufficiency is argued on appeal. Was vagueness argued at the violation hearing?
I don't believe so, Your Honor. I believe I can't say, because I know the defendant did file a pleading at that time, and I can't recall if it was enumerated in there, although I don't recall it in my recent review of the transcripts. But again, looking to I would urge the court, if we're trying to figure out the core of the prescription here, I think it's clear from the procedural history that leaving the foster home without notice, without permission, even if we don't have the agreement, was within the core of the prescription.
For how long? Leaving for how long? Under what circumstances?
Well, certainly the defendant was violated after, I believe it was, there was a few day lapse, a 1 month lapse, and then the most recent one, he was served after 2 days.
So the question, I mean, when you say the core prescription, I mean, the original one, he was gone for about a month and a half or something like that. But I don't mean to be cavalier about this, but even if we were to accept as a basic proposition that he knew it was not acceptable to absent himself from the residence for an extended period of time, what are the boundaries? What are the circumstances?
Well,
What are the terms?
I guess another thing I could point to that is in the record, that is in the transcript of the most recent violation, is discussion. There is discussion of the defendant's curfew, or the juvenile's curfew, excuse me. So I would suggest that at a minimum, the juvenile should have been aware that in order to be out past any curfew.
What was the curfew?
I believe there was discussion about changing it, and so I believe it was maybe initially 8 or 9 p.m. and the probation officer in the most recent violation hearing wanted to make it earlier, and the judge declined. But I would suggest, no matter what the curfew was, being gone for 2 days, a 48-hour period clearly violates the curfew.
Well, yes. But all of our evidentiary support for the existence of a curfew is by indirection, by oblique reference, and not to presentation of what the terms were. What do you have to say about the Article 30 question?
Well, Your Honor, I would say the sentencing judge has to set the conditions of probation, right? That much is clear. But what I would suggest is that
outside of the juvenile context, if I'm a sentencing judge and I sentence a defendant to probation and include in the conditions of probation to be such limitations as the probation department imposes, is that okay? I
would suggest that condition's not okay. And
tell me the difference between the juvenile setting, where I say the conditions are not to violate whatever the DYS imposes.
Well, number one, I would say initially that there is a difference between a juvenile setting, but absent that, number one, the DYS agreement is an agreement, right? So there is presumably at the time that this is imposed some document that could be referenced. And is
the judge involved in the crafting of the terms of that agreement?
I don't believe that the judge is involved in the crafting of it, but I don't know that the judge has to be involved in the crafting of it to delineate it as a term. And the
so delegation is okay if the defendant acquiesces in the delegation.
I think it can be okay if the defendant acquiesces in the delegation of the condition. I also think it can be okay if
what's your best case for that?
Is predefined. For the
suggestion that a judge can delegate to an executive agency the authority to develop the particular conditions of probation, and that's okay if the defendant agrees to those conditions with the executive agency.
Well, I would just say, Your Honor, that I don't know if I have a case that's.
I don't know of any case that says that's okay.
That's directly on point to that, but what
what's the closest case you have?
I think that there can be a contrast made with or maybe a comparison to Gomes, where that's cited in the brief. I don't have a citation, but just the principle that there is, I would argue, some burden in some instances to preserve an issue in sentencing. I'm
just asking you for some reference to some authority for the basic proposition you're urging that it's okay for a judge to delegate to the DYS the establishment of the conditions of liberty.
Well, I don't know that the right to delegate is the best argument here. So I'm trying not to get hung up too much on that. I think the argument is that there's not a delegation when the agreement is in existence at the time that the condition's set. in instance when there already is an agreement and there's terms of that agreement.
My understanding is that the DYS reserves the authority to modify that without going through the changes.
And again, I would point to the procedural history here. There's no evidence that the DOS added or changed any conditions, and the conduct that was the subject of the violation was the same every single time.
There's no indication of what the conditions were, when they were established, and whether they ever changed. We don't have anything on that whatsoever.
And so to that point, Your Honor, I would say that you know, if there was some problem with DYS, you know, changing the conditions or modifying the conditions so that that now the executive branch is controlling the conditions, we don't have any evidence of that here. And to the contrary, because the same conduct was a violation every single time, I think that supports the inference that what was violated.
That is the manner in which the condition was imposed as a part of the juvenile's probation, right? I mean, if the judge wanted to cabin the conditions to those that were in place at the time, that would have been easy enough to do if the agreement was known to all. If there were some conditions that were part of that and others that were not, that's a different question. We have no idea what was out there. But this is a bit of an open-ended blank check without regard to any possible future alteration outside of the rigors of changes to probation conditions more generally.
I think in a hypothetical situation, but I would suggest the record does not support that. That's what happened here. And actually, I do have it.
Your time is running short. Oh, I don't want to interrupt if you have a citation or something that you want.
I did just want to provide because I just thought of something to answer Justice Green's question on the citation of powers. The defendant included Commonwealth v. Terrell in a 16L letter, and I would just note that Commonwealth v. Terrell does talk about, it's not a case citation, but Chapter 119, Section 58, the combination sentence structure for juveniles. That does indicate that when there's a combination sentence, the adult sentence is suspended pending successful completion of probation, which, quote, shall include successful completion of the DYS commitment. So the legislature at least has contemplated that DYS could be a part of probation. So I would.
Can I ask, your time is short. In this probation violation, he was away from the foster home for 2 nights. Is that right?
In the most recent violation, yes, that was.
How does that meet your burden of demonstrating a change of residence?
Well, Your Honor, I think that there's a critical, I think, question that the court needs to answer to get to that. You know, does the judge at that violation hearing, can that judge consider the history of this case in this juvenile situation, or does the judge have to go on only the information that gave rise to the instant violation in kind of determining, I guess, the almost the defendant's or the juvenile's intent?
Well, what's in the record, right? I mean, the answer to your question is the judge can consider whatever's in the record before him or her, right?
And so if the judge can consider everything in the record, and this was the same judge that had presided over the most recent 2 violation hearings, which the Commonwealth suggests that the judge can consider everything, especially in the case of a juvenile, where the rehabilitation is so important and we're really looking for the best interest of this juvenile. And if the judge can consider everything, then I think the judge the defendant went missing for a month. There was a violation hearing on March 11th pertaining to that. And then 1 month later, the juvenile's back again, missing again for another period of multiple days.
When was the juvenile away for a month?
That was from December to January of the next year. The juvenile was then in DYS custody.
Yes, what year? What are the dates?
It was until January 2019 was the end.
And when is this violation?
This violation is noticed on April 11th, 2019.
And had the juvenile been living in the foster home in between those two dates for the 4 months in between?
I don't know the record's clear yet how much of that time the juvenile was in the foster home. I do know that there was also testimony that the juvenile did have difficulty with maintaining residence or presence at the foster home. And
Do you
that
have
essentially,
evidence that the juvenile was in the same place for the month and a half as for the 2 nights?
no, we don't have evidence that the juvenile was in the same place for that month and a half and that 2 nights.
Your time is up. I don't want to take more. So.
If there are no further questions.
That will conclude the argument in this case. Thank you both. The case is submitted. Names or other material. Attorney Kirchway, you may begin.
Thank you, Your Honor. As you know, my name is Deborah Kirchway and I represent the mother. This was, as you know, a review and redetermination case. And after the first trial, the judge did not terminate mother's parental rights, found that she was a good parent when sober and not with father. And in those 2015 findings, the court expressly said that mother should be afforded the opportunity to demonstrate that she successfully engaged in domestic violence services, terminated the relationship with father, and continues to maintain her sobriety. And that phrase in the 2015 findings is key to the fact that the judge, even though the judge said that the burden of proof was on DCF, as is the case, it's clear from that statement and from the findings that the judge really did expect mother to prove that she was fit. The court relied on substance abuse, domestic violence, housing issues, mental health issues, and the children's needs in making its determination. And I will address each of those in turn. But first, looking at the big picture, if you look at those 5 main bases for the court's determination, the evidence shows either that mother did the right thing when it came to housing, mental health, domestic violence, and trying to get information about her children, or there was no evidence that she did the wrong thing with regard to substance abuse. DCF simply failed to meet its burden here, and the court shifted the burden of proof to mom, and that was completely improper. So I'm going to start with the hardest part here from mom's perspective would be the substance abuse concerns. And it's clear, again, to remember the burden of proof is on DCF. So the court's concern that mother might have been using is not evidence that she was. And in fact, DCF admitted that it had no evidence that she was using drugs. The undisputed testimony from mom was that she had had no use of illegal drugs.
I'm sorry, aren't missed screens evidence of drug use? Isn't that an inference that's permissible?
No, Your Honor. I would argue that it's not. No inference can be drawn from mom's failure to provide evidence.
No. It's not the failure to provide evidence. It's the affirmative evidence of missed drug screens that were required. I thought that we had cases in which negative inferences have been drawn from those missed screens, and they've been treated as positive screens. I may be mistaken about that, though.
Well, Your Honor, I don't believe those cases were raised by the appellees. If they are, then I stand corrected. But an inference can only be drawn from someone's failure to provide evidence if the other party has presented affirmative evidence to the contrary.
There's more than the missed screens, though. I mean, she has an opiate addiction. She was treated for it. There's evidence that she used narcotics in front of the oldest child. She had the episode when she was vomiting on the yard. She had track marks. The twins were born addicted to opiates.
So yeah, there was evidence from prior to the first trial, for sure, of mom's use. But that had been adjudicated, and the court found at that time that mother had been engaging in substance abuse treatment for the 12 months prior to those findings. And so if you look at really the evidence is supposed to be what happened after that. Yeah, that's all bad evidence. I concede that.
Correct me if I'm wrong, she did do some treatment at Arbor, is that the name of the facility? But based on her inconsistency in attendance and failure to abide by the rules, she was discharged from the program.
Your Honor, that's correct. But if you look at the overall picture of what she did do, the social worker testified that she was in treatment through May of 2016, and that she missed her Suboxone and her groups from May of 2016 to July of 2016. Then she was back in treatment again from July of 2016 to August of 2016. And Mom's undisputed testimony is that she then started in a new program within a week of that. So if you add up the total months,
but I'm sorry to interrupt again. The judge doesn't have to credit Mother's testimony, even if it's undisputed, yes?
The judge does not. The judge can discredit her testimony, but that does not equal evidence to the contrary. So the judge can discredit Mom's testimony, yeah, that she's been...
I was not implying that it meant evidence to the contrary. You're saying in support of her treatment that she told the court that she was doing treatment. That's
Correct.
Not evidence that the judge does not have to credit that.
No, the judge does not have to credit Mother's testimony as to anything, but there has to be evidence.
The point is that she had a rather long history of unresolved opiate addiction. She missed screens that she was required to provide. And my recollection of the case law is the same as Judge Rubin's, that there is a permissible adverse inference to be drawn from the failure to submit to required screens as part of the service plan.
Again, Your Honor, if that case was brought up by the appellees in their briefs, I missed it, and I can't say that for sure, but
our task in evaluating the judge's findings and ruling is to ascertain whether they are supported on the record in the evidence as a matter of law.
And I would point you, Your Honors, to the case which I cited in my reply brief, the adoption of Laughlin. It is an unpublished case, but in that case, the court found that it seriously questioned Mother's sobriety because she was caught with drugs with intent to sell. Okay, and we don't even have that here. And that was vacated and reversed for consideration without reliance upon the substance abuse findings. So I would argue that this is even better facts than the Laughlin case, and the substance abuse findings should not stand. There was just no positive evidence that she was, yes, I concede. Does it look bad that she can do some screens? Yes, but the burden is not on her to prove lack of substance use.
Attorney Kirchway, before we get too much farther, there's one thing about this case that has been troubling me since I picked it up to begin reading, and that is the length of time that it's taken to get here.
Yes.
The decree entered in January of 2017. The transcripts were not ordered until May of 2018. The record thereafter wasn't assembled until August of 2019. And now here we are a year and a half after that.
Yeah, Your Honor, I was troubled too when I received the case just earlier in 2020. I was a subsequent appellate counsel. I can't explain what happened, although it does appear that there was some missing testimony. One of the witnesses' testimony had to be reconstructed, the half-sister's testimony. I did see that.
Well, I don't mean to hold you accountable for it if you've only recently acquired the case, but we do everything we can to move these cases along expeditiously. It's the appellant's burden to assemble the record to order the transcript and to move diligently to prepare the case for appeal.
I understand it is a troubling length of time. I agree, Your Honor.
In the life of a child, those 4 years make an enormous difference.
Absolutely. Since I don't have a lot more time, I would like to address the issue about, well, first of all, on housing, The finding that mother didn't have stable housing is clearly erroneous. She had lined that up with her aunt. The aunt confirmed that housing was available. There was a home study that passed the home passed, clearly erroneous that she didn't have housing. The issue of the knowledge of children's needs, Mom met with the adoption social worker 3 times and contacted the next adoption social worker 3 or 4 times. She clearly made efforts, and DCF was giving her these random hoops to jump through, not specifying how long she had to be quote unquote consistent with her contacts, and they really just withheld information about her children from her, didn't bother to tell her that she had every right to have her lawyer get it for her. That's just wrong. In terms of the mental health treatment, she clearly, her undisputed testimony was that she was getting treatment and was on meds. And with respect to the domestic violence, in so many of these cases, we hear how the parent chose the relationship with the abuser over their children. But in this case, Mom did the right thing. She ended that relationship with father. The last incident was in 2014, April 2014. She attended a domestic violence group. There were no more incidents. She ended the relationship. Her actions demonstrate that she can keep her children safe. And finally, with respect to the foster family, I mean, it's unusual the amount of, if you look at the language in the evidence, in the record about the foster family, to hear that they were overwhelmed, they were in crisis just right before trial, the summer of 2016. That foster family was in crisis. They were unpredictable. They were chaotic.
These children are badly damaged by the time they were with father and mother, right?
They certainly had been through a lot, Your Honor.
Okay, and so some of these overwhelming things, which include urination on couches and floors, you describe in your brief, I think it's your brief, the smell of urine in the house. A lot of this has to do, apparently at least, with the horrible nature of the abuse they suffered. Not with any shortcoming, at least it's been shown, I don't think, on the part of the pre-adoptive parents.
Well, when you've got the daughters, the birth daughters of the foster family saying, it's crazy here, it's crazy, we're all going to go to family therapy.
So let's say, for example, we were to conclude that the findings of unfitness are adequately supported. There is no alternative plan then, right?
Well, yeah, there was an alternative plan, which was the grandmother said that she could care for the oldest child, and the aunt had testified that she, with help, you know, just like the foster family got tons and tons of help, with help, she could care for the boys, but not by herself, and she was willing to help in any way that she could.
She's willing to help, but that's not a placement. Isn't the placement plan to be with the mother in the aunt's house on a indefinite but temporary basis? Isn't that your alternative, or the mother's?
Well, that was mother's preference, was that, but in her written closing argument, or something written after the trial, I believe it was a written closing argument, she said, in the alternative, please consider my family members. And those family members had testified as to their abilities. And the court never even considered Mom's plan. And just to have such an unusual amount of negative evidence regarding the foster family, certainly the court didn't address an iota of that negative evidence. And that should have been addressed, and the failure to address it means that no deference should be given to those findings whatsoever. The cases regarding, cases cited in my brief, such as the Laughlin case regarding substance abuse, Iris governing the substance abuse also, the Imelda case for the domestic violence, all of those cases suggest that the appropriate action here is to reverse the termination decree and remand for further consideration of the plans. So that's what I would ask you to do. Thank you.
Thank you.
Thank you.
Okay, we'll hear from Mr. Cuttle for the department.
Thank you, Your Honor. Before I begin, can you please let me know when I'm coming up to the 9 minutes? I'm not able to see the timer.
You have 9 minutes now. I'll let you know when you have about a minute left.
Thank you. William Cuttle for the Department of Children and Families. Your Honors, we're asking the court to affirm the trial court's decision in this case. The overall picture of this case, frankly, is one of, as the court found, that these children need stability and permanency in their life, and that despite some of mother's efforts, she is incapable of providing them with what they need now and in the future. Clearly, as I set forth in the department's brief, I don't want to just verbatim go through everything that's in the brief, Your Honors, but clearly mother had a longstanding substance abuse history, mental health struggles, domestic violence issues, and unstable housing. This case came before the court in November of 2012, and the second trial didn't begin until September 2016. There were 4
Do you
years.
have any insight into the question I posed to your sister about the delay in getting this case ready for appeal?
Your Honor, it is a serious issue. The transcript seemed to be the initial reason why it was being delayed. I'm not sure what happened. There was a transcript or a hearing that had to be transcribed. That took a long period of time. There were several appellate attorneys before Attorney Kirschway came on the case that delayed the whole process. Additionally, to be frank, I delayed the process of completing the department's brief with some medical concerns that I've been dealing with. And I apologize to the court for that.
I certainly understand that, and I was not looking at so much at the delay after it came to the appeals court. That's something that we can monitor and supervise and
Right.
address as those arise. But what struck me off the bat was the year and a half between the entry of the decree and the order of the transcript,
Right.
and then a year after that before the record was assembled. It ordinarily shouldn't take more than 60 days for the record to be assembled after the transcript is ordered.
You're right, Your Honor. I'm not certain what happened. It did not serve the children well in this case.
Please continue.
Thank you. So clearly, the court made findings in both the first trial and the second trial of 300 findings. Mother was given opportunities to address her substance abuse issues, the domestic violence issues, her mental health issues. She made some attempts. She made some efforts at the end of the first trial, but clearly she had a substantial substance abuse issue that affected the children. She wasn't able to consistently complete treatment, as the court found. That's undisputed. And she was terminated from her program. And in addition to the substance abuse challenge that she continued to have at the time of trial, it's very important to point out that mother, even though she participated in the domestic violence class, she clearly never acknowledged the domestic violence that she suffered at the hands of the father, nor did she ever acknowledge the domestic violence that the oldest child and the children were exposed to. She never did, no matter what the treatment was. And mother's argument that somehow that the domestic violence evidence is stale is without merit. These children were badly damaged, as Justice Rubin pointed out. The court spent in the second set of findings, from finding 78 to 124, just enumerating all of the special needs that these children have. It's overwhelming, the issues that they're struggling with. And the foster parents who became the pre-adoptive parents, they've cared for these children on and off since 2012 and continually from March of 2014. Yes, the evidence shows that the house is chaotic. That's all that evidence is in there. But this judge sat on this case, heard testimony. There were 1,800 pages of transcript for the review and redetermination hearing. She heard from numerous witnesses. She heard the foster mother's testimony about all the concerns that were going on in her own family, the struggles with the kids, trying to manage all the treatment providers. The judge found in the conclusions of law that these foster parents were meeting all the children's needs, that they were providing the children with an essential, stable environment despite their chronic instability, and that it was in the best interest of the children to stay in this home. The mother's argument that for somehow the court shifted the burden is not accurate. The court in this case at the beginning of trial, I believe it's on page, starts on 104, goes to 110. The court has a specific discussion with the parties about the review and redetermination process, that the court always has the burden to prove their case, and that's what happened here.
Attorney Connell?
Yes.
Justice Rubin.
Yes, Judge.
Was there an alternative plan presented or not really, aside from the plan of placement with the mother, who presumably once she's found unfit, if we find that a supported conclusion, that's not a viable alternative anymore? Was there an alternative beyond that?
No, there wasn't, Your Honor. Thank you. I'm glad you asked me that. And as we point out in our brief, mother's plan was a reunification plan. She said at the time of trial that she wanted to take the children and live with the maternal aunt temporarily until she could get her own housing. The idea that mother had achieved this goal of stability is not based on what's in the record. Mother never had a stable place to live, sadly. It's a very sad situation, but she did not have a place to live. She never testified that she wanted to have the children live with her mother. The argument that's being made about an alternative plan is, an effort just to try to create an error of law that doesn't exist. The court wasn't required to comment about all the evidence in this case, as the case law points out clearly, and did not do so. I mean, the plan was for the children to be with the M family, who they have been with for many years.
Attorney Connell, you have 1 minute and 46 seconds left.
If you have no other questions, Your Honor, I'll rely on the department's brief. Thank you very much.
Thank you. For the children?
Good morning, Your Honor. May it please the court, I represent the children in this matter. The best interest of the children are paramount, and their interests scream for permanency. The children have been in DCF custody since November of 2012 and were removed from mother's custody on 2 occasions. The oldest is now 12 years old and the twins are 8 years old. All 3 children have significant special needs that have been exacerbated by mother's neglect and desperately need permanency to finally be on the road to recovery. Those needs can be met by affirming the decrees of termination. The juvenile court's decree should be upheld because the findings were supported by the preponderance of the evidence, and they collectively and convincingly demonstrated mother's unfitness. Adoption by the pre-adoptive parents certainly meets the best interests of these children. None of the issues raised by mother requires this court to disturb these termination decrees.
Have you spoken recently with your clients?
Yes, Your Honor, on Monday I did for a substantial amount of time.
All 3?
I spoke with 2 out of the 3. One was ill, but I did set eyes on that one and he did wave to me.
Okay. And there's no change of position on any of their parts?
No, I spent an hour and a half, Your Honor. I wanted to ensure that there wasn't a change in position. And in fact, I think their position is more solidified at this time than it was previously.
And the placement, they remain in the same placement?
They remain in the same placement, yes, Your Honor, and they continue to refer to their foster parents or pre-adoptive parents as mom and dad. So thank you. With respect to the foster parents, they have provided the stability for these children that they have otherwise lacked. As I indicated, they They called them their mom and dad. While there were certainly some issues that were raised during trial, they were actually addressed in the findings of fact. Maybe not the way mother advocates, but they were addressed. And these children, substantial special needs, and they're acting out in their issues aren't solely related to their placement. In fact, these issues occur whether they're in daycare, whether they're in school, whether they're at their home. With respect to mother's argument that the court impermissibly shifted the burden of proof to mother, and that certainly is not the case. In fact, in adoption of Lorna, this court uses the term demonstrated in the very same manner as the trial judge. In that case, the court described how a parent demonstrated limited parenting skills, failed to demonstrate any insight or causes which led to a child's injuries, and demonstrated a lack of effort to remedy the conditions, creating a risk of harm. The same thing was stated in adoption of Eric, which also uses demonstrated in the same manner. So to claim that the trial court's use of the term demonstrated when after explaining all the evidence and explaining how mother failed to follow her service plan certainly did not serve to shift the burden to her at all. With respect to mother's long history of substance abuse, it certainly has impacted the children, such as the twins suffering from withdrawal after their birth and the oldest child witnessing extensive drug use, but also having to endure horrific beatings that his mother continued to claim never happened, notwithstanding the photos of one of the beatings in record appendix number 2 on pages 268 and 275. Mother's denial of this horrific physical abuse indicates that she cannot meet these children's needs with respect to the damage inflicted, because she doesn't even recognize it ever occurred. How can she meet these substantial needs of the children and assist them in overcoming the abuse when she herself does not recognize it? Excuse me. Finally, one last thing I did want to point out. While the mother claims that the foster home was chaotic, the judge directly addressed that issue when she indicated that the family environment would be less stressful and chaotic with time and implementation of the strategies. And that's found on page 77 of Record Appendix 1. I see my time's up, and unless there's no other questions from the panel, I would rest on my brief.
Seeing none, thank you. Thank you all. That concludes the argument in this case. The case is submitted.
Thank you, Your Honor.
Meeting recording was stopped.
We are live and on the record.
The next case on our list for hearing now as we move into the afternoon is case number 2020 P672. This is a case involving the adoption of a child. Attorney LaPresta, you may begin.
Thank you, Your Honor. May it please the court, good afternoon. Sarah LaPresta on behalf of Mother. Mother consented to a guardianship and later petitioned to remove the guardian when she began to have serious concerns about the guardian's ability to care for the child. But in the proceedings that followed, despite any lack of any prior finding or even allegation of unfitness on her part, the court found Mother unfit and terminated her parental rights. And in making that finding, the trial court made 4 critical errors. It refused to allow her the chance to visit the child ever to learn about the child's needs, and then used her lack of experience and knowledge to find that she was not fit to care for the child. It denied mother the chance to present expert testimony that would have shown her ability to properly care for the child, how to address the child's bonding needs, and an appropriate transition plan. It misapplied the Chapter 210, Section 3 factors to erroneously find that mother abandoned, neglected, and failed to support the child. And it found mother unfit based on the child's bond with the substitute caregiver without making the required findings about whether mother would be unable to adequately address the severance of that bond. And turning first to visitation, the trial court found mother unfit based in part on her willful failure to visit with the child during the case. But during the period between the granting of the guardianship and mother's petition to remove the guardian, mother had no legal right to visit. And in addition, guardian cut off mother's access to the child on social media and served her with a no trespass order. So mother
Did the mother pursue any efforts to obtain an order for visitation?
Yes, she did, Your Honor. When she filed a petition for guardian, she also filed for visitation, and she renewed that motion several times throughout the case.
I thought the judge's finding.
The trial court, nevertheless, found that her
Attorney Lopresti, yes. I thought the judge's factual finding was about no visitation prior to filing the suit. Am I mistaken about that? That's what the finding of fact is, right?
The judge did find that she failed to visit before the filing of the petition for guardian. She did not have a legal right to visit.
Yeah, but that's only because she had given that away.
Well, I would point out that the guardianship order did not prevent the guardian from allowing mother to visit the child, but the guardian
did she ask for visitation prior to the filing of the lawsuit?
She didn't, and it appears that since there were no trespass orders and there was a restraining order filed, mother didn't really have the opportunity. She was also blocked on social media.
I may be mistaken. The restraining order came after the father threw the brick through the window?
It's not entirely clear, Your Honor, from the record, and the record does appear to interchangeably use the no contact order for mother and the restraining order against father. So it's not entirely clear. Guardian did at one point testify that she asked for a restraining order against father in response to a disagreement she had with father.
Can I ask a couple of background questions? Because I don't really, they're not addressed in the briefs, and it's really about this whole area of law and what the background law is here.
Yes, Your Honor.
I understand that surrogacy contracts are enforceable in Massachusetts. Is that correct?
I believe they are, Your Honor, yes.
Do you know why no surrogacy contract was entered into here? Do we know? Is that in the record?
No, Your Honor, it's not in the record.
I gather that it was on legal counsel's advice that what was done here was a guardianship that would be then changed into an adoption. Is that right?
Yes, Your Honor. The guardian had legal counsel at the time. The parents did not.
Now, I don't know much about the area of surrogacy, which is sort of what I'm asking about here. If they had done that, are there restrictions on doing this as simply a consent to adoption, agreement for adoption with the 4-day revocation period that would render, I'm just trying to figure out why someone would do it this way, guardianship, 6 months adoption, rather than the other way. Are there procedural or financial burdens that are attendant upon the other way?
It's not clear, Your Honor, why it was done this way. As far as I'm aware, an option available to the parties would have been to do an adoption surrender at the time of the child's birth. For reasons that are not in the record, the parties did not do that. Instead, they entered into a guardianship. Either way, there is a 6-month residency requirement before the petition to adopt could enter. So we do know that the guardian was not able to adopt the child for 6 months, but it's not clear from the record why it was.
Petition for adoption in this case was filed more than 6 months after the child was born, right?
It was filed at approximately 6 months, Your Honor, yes.
But the residency, to just go back to Judge Rubin's point, the the residency requirement does not impose any limitations on the ability to enter into a consent for adoption and to have the adoption go forward, simply not to be finalized until after the residency is completed.
That's correct, Your Honor.
I don't know that much about surrogacy requirements either, but I do understand that there are a variety of rather significant formal limitations put in place because of concerns about the nature of surrogacy agreements.
I would agree with that, Your Honor.
And it appears to me as though this was to call it informal or casual doesn't even quite do it justice. But the judge nonetheless decided in effect to give force to an informal surrogacy agreement.
The judge certainly did mention that in her rationale, Your Honor, and I would also characterize it as informal. But what we know is that at the time of the child's birth, what was executed was a consent to guardianship, and a guardian was then entered into. And it was at that point, mother did retain the right to file to revoke the guardianship. And that's exactly what mother did.
What does it mean that it was a permanent guardianship?
That's as opposed to a temporary guardianship, which I believe lasts 90 days and is usually entered into on an emergency basis. So any other guardianship is permanent in the sense that it remains in effect until the child's 18th birthday or until it's revoked for another reason.
Can I ask a question about guardianship?
Yes.
Can any parent give their child over to any other adult as guardian? Could I, if I had a child, could I give it over to someone I met and just do a guardianship? Or is there review of that? What are the standards before it can be entered? Does unfitness have to be conceded or shown? What's it all about? I've never seen, I don't know that any of us has ever seen exactly this fact pattern, but.
So unfitness does not need to be shown. What the parents did was they issued a consent to guardianship.
Okay, but I just asked, can anyone do that? Can a family with a child find a stranger on the street and give their child to that stranger through a guardianship, and all they have to do is consent? There is no substantive rule about who can or can't either be the person consenting and on what basis, or the person accepting the guardianship?
It does have to be agreed upon by the court. So in this case, what we have is a petition for guardianship that the guardian filed with the court, and then shortly thereafter, the court that did approve of that guardianship. And on that form, and in the decree of approving the guardianship, the justice found that parents consented, not that there was unfitness. There is a spot on the form where a judge can find that parents are unfit. But what happened in this case was the judge, when the petition was presented to the probate and family court, issued the petition, and found that the parents had consented to that guardianship.
So what is your answer to my question? Can any parent go find a stranger and consent to that stranger becoming the guardian for their child? Anyone can do that because there's a form that you can file? Is there a statute that permits it, and is it literally standardless? I can literally choose anyone to be the guardian of my child. Is that right? I mean, I have no idea. I'm not being facetious. I'm trying to figure out what the lay of the land is here.
To a certain extent, yes, Your Honor, that is correct. I believe that the statute requires the guardian to be over the age of 18. There may be some other requirements in the statute, but by agreement, yes, parties can agree to enter into a guardianship.
Thank you. Your time is up. We'll hear from Attorney Katz. You're going to have to unmute yourself. Attorney Katz, unmute yourself, and then you may argue. Thank you.
Sorry, Your Honors. May it please the court, Attorney Daniel Katz for the appellant father. I would like, Your Honors, to keep in mind several principles in reviewing this case. The first one was set down by the Supreme Judicial Court a little over 50 years ago in Kauch Petitioners. And the Supreme Judicial Court said the settled law, founded on express legislative policy and uniformly adhered to by this court, is that a parent is not to be deprived of the custody of his child in the absence of a finding that he is unfit. In making this declaration, the SJC actually cited a case from 1932, Richards v. Forrest. The second principle, which was set down by the SJC in custody of a minor in 1979, is that it is constitutionally demanded that a judge exercise the utmost care in rendering a judgment which will deprive a parent of custody.
My understanding is that your client testified that he was pretty sure he wanted the child back and that he smirked throughout the proceedings whenever the obvious gravity of what's going on here was raised. Why isn't that important evidence about his fitness to have this child who he participated in the creation of in order to give away to the guardian, who he had never met or communicated with?
The judge, Your Honor, is correct that the judge did note of the smirking and saying the pretty sure. But I think when you look at the standard of proof that it must be full, decisive, and clear, those two, a comment, an observation by the judge.
And throwing a brick through the window of the house where the baby may have been hit.
So in terms of the brick, Your Honor, that finding is clearly erroneous. The judge can, as you know, evaluate the credibility of witnesses and make findings of fact accordingly. The guardian, whom I call in the brief the guardian, she testified that a brick was thrown and that there was a note. She also testified that she filed a police report. However, no police report was entered into evidence. On the stand, the father did deny that he threw the brick. Based on that denial, the judge made an affirmative finding
Attorney
that the father.
Attorney Katz, this is a credibility question. The absence of independent third-party corroboration in the form of the police report does not bear one way or the other on the judge's authority to credit the guardian's testimony.
But
and the circumstantial evidence, the judge does not need to treat the father's denial of throwing the brick as evidence in support of the fact that he did. The judge can draw inferences from the content of the note as testified to by the guardian, and the possibility that it was from the content of the note, likely either the mother or the father who threw the brick.
But Your Honor, this court has said that a judge cannot make a finding of fact on disbelieving a witness's testimony.
I'm not suggesting that the judge did any such thing. I'm suggesting that the judge had a brick that was thrown through a window, according to the mother, with a note that said, that gave language suggesting that it was thrown either by the mother or the father. And the judge, faced with those two likely prospects, could infer that one of those two threw it and settle on the father as the more likely of the two.
I think that is speculation based mainly on disbelieving testimony.
The judge could make that same inference without the father taking the stand and offering any testimony on the topic whatsoever.
But there was no affirmative evidence, Your Honor, that the father was the one who threw the brick through the window. I think I would have, if the police report had been admitted into evidence and there was evidence in the police report that an investigation had taken place and the guardian had said, well, I think based on what's going on in my life, I think it was either this mother or this father.
Mr. Cat, before we run out of time, it wasn't just the brick, though. Doesn't he also threaten her over the health insurance?
There is that, Your Honor.
And unlike the biological mother, he never sought parenting time with the child.
That is true, Your Honor. But still, one thing that the judge failed to do, and in terms of whether this court gives deference to the judge's findings, is completely ignored the positive evidence of the father exhibiting parenting skills, and quite frankly, very positive parenting skills that he demonstrated towards mother's own biological children. In addition, Your Honor, I implore you to take note of the fact that the father attended all 11 prenatal appointments. Combine that with the fact that the father was involved quite positively with mother's own biological children. And coming back to those principles, I see my time is up.
We have those. Your time has come to an end. You can rest on your brief for what remains. I think we hear next from Attorney Williams for the Guardian.
Thank you, Your Honor. Good afternoon, Attorney Heather Jill Williams for the Guardian, who I refer to as the intended mother throughout my brief and will do so today. This is a very interesting case. The issue that this court is faced with looking at is similar to that which the lower court was faced at looking at, and that simply is, who is this child's parent? What is in the best interest of the child? And are the biological parents unfit?
It seems to me that the last of those questions is the most salient, because had the parties chosen to frame this or to structure it in one of the other legally recognized alternatives, we wouldn't be having this conversation. So I will say to you what I said to your sister, Attorney Lepresti. It appears, to my eyes at least, as though the judge was confronted with a circumstance that appeared to be an intention or a belief at one time to enter into a binding surrogacy agreement. The failure to do so in a legally recognized manner, and then sought to give force to that original intent by shoehorning it into an entirely separate process. We heard, you may or may not have been watching our session before the argument in this case, but we heard just before this case, as we often do, a case involving the Department of Children and Families petition to terminate parental rights based on unfitness. In those cases, the evidence supporting a finding of unfitness are substantially greater, and I would be hard pressed to identify any case on the facts where unfitness was found in the ordinary DCF setting, resulting in termination of parental rights, where the facts concerning the fitness of the parents were like these. So with that preface, I would like you to please ground your argument in some of the more traditional indicia of unfitness that we would ordinarily see, because what I see here is a voluntary surrender to guardianship at the time of birth, and a failure diligently to pursue visitation until after the petition brought to terminate that guardianship. That is, to me, the primary ground of unfitness that the judge seized upon.
Thank you, Your Honor. It is correct. And just to correct the record, there is nothing in the lower court record that either the intended mother / guardian or the biological parents had the advice of counsel prior to this case beginning. They entered.
How did they hear about guardianship and adoption? I thought that was because maybe I read it in a text message or something, because the guardian had spoken with a lawyer.
So the guardian had a consultation with a lawyer at the very beginning of the process. There was never an engagement of an attorney. The guardian did not, they believed, the record reflects that a caregiver affidavit would authorize enough for guardian to take the child home. It was the hospital that led guardian to the court. And at the Hamden County Probate and Family Court, there's a service center, and there's some individuals that help people fill out the paperwork. And that's
the fact that they bumbled their way into this manner of a surrogacy agreement because they didn't know the legal requirements is, while understandable to some extent, does not excuse it for legal purposes. And the concern I have is that the requirements that are in place, the very strict formal requirements that are in place around surrogacy, are there for a reason, to allow this to go forward to endorse this. You said at the very beginning they consulted with an attorney. The guardian consulted with an attorney. At the very beginning, this was a couple of Facebook messages exchanged with language that again, informal doesn't begin to capture the casual degree to which the parties involved here were approaching the creation of a life.
That's correct, Your Honor.
And my concern is that to endorse this behavior without adherence to the formal legal requisites opens a very, very dangerous pathway. And I'm troubled by the fact that the parties have placed the child in this jeopardy, but both sets of potential parents here are far from ideal. Ideal is not the standard that we apply in assessing unfitness. And so again, I would urge you to go back and the judge found unfitness, but again, to my eyes, the bases on which the judge rested that ultimate conclusion are far from the things that we usually see in a case involving the termination of parental rights.
Absolutely, Your Honor. I will very quickly address that. They're one and the same. They dovetail. In this case, you have biological parents that created a life that never actually intended to parent that child. They didn't even actually consider this their child. The biological mother, when testifying about her quote unquote youngest child, even after this case had been pending for the child, this child was 18 months old. She was testifying about her youngest child. She wasn't talking about this child. She was talking about her second youngest child, who she considered her youngest child. It is very important for the court here to realize that the finder of fact in the lower court had the advantage of seeing how these parties behaved throughout. It wasn't simply a matter of snickering. It was palatable in the courtroom that the biological parents were very disinterested in this child. When visitation rights were denied, there was almost no reaction from either parent. The father is quoted as saying, and he says it was the nail in his coffin. This is on the transcript, volume 1, page 152. I'm pretty much thinking I might want him back. He wasn't clear that he wanted this child. Biological mother wasn't clear that she wanted the child. She didn't know his date of birth. I recognize that in the reply brief, there was accusations that it was unfair for in guardian's brief to quote that the parents did not make any efforts to learn about the child because they were in the throes of litigation. Well, there was a lot of discovery in this case. There were depositions in this case. In fact, in the record, I cross-examined the mother, and this is in the transcript, page 114, where I go line by line. You had the opportunity. You could have asked, how is this child doing? What does he like? What doesn't he like? What does he need? And biological mother acknowledged, yes, I could have asked those questions, but I didn't. So
all of that is certainly fair game for criticism, but a finding of unfitness is a very, very high bar.
Absolutely, and they were unfit because they had no interest in the child. They knew nothing about the child, and they had no plan to bridge a parenting from the child's only parent that this child had known since birth into their care.
What is the closest case that you have in our appellate jurisprudence that rests a finding of unfitness on an expression of no interest?
So these are in the abandonment cases. These parents abandoned the child. They left the child with a stranger and made no further inquiry about the child's well-being until they had a potential loss of benefits through mass health, when the comment was either adopt him or give him back, or I'm not losing my benefits over that. The judge made appropriate findings that these biological parents.
Okay.
You want to ask a question, Bill? Judge?
We've been assuming, and I don't know the answer, that unfitness in the context of a guardianship is the same as unfitness in a termination of parental rights. Is that the case?
It is a similar standard, but in a case such as this, I believe there is, as my sister will be addressing in the case law relative to probate cases and the right to counsel, there is a slightly less constitutional threshold when dealing with due process issues in a case where it's a voluntary giving of a child versus state intervention.
Let me ask you this. I have these go back to the questions I asked attorney for the biological mother about the background law, like the backdrop of all of this is. So I gather a guardian can bring a petition to adopt, and even though they're not DCF, they can argue that consent to adoption by the parents should not be required. Is that that's a thing? I mean, this is the first case I've seen like that, where DCF isn't the one asking for termination. Is that in the statute? Are there any cases on what the standard is?
So the cases that I found, and I did not cite them directly, but they were dealt with in terms of at the lower court level and also in the brief, is that there has to be a finding of the unfitness to such a level that termination is necessary. And those are the same cases that the lower court judge relied upon in her specific findings, marching through each one where the burden was met that the biological parents' rights should be terminated.
In cases where DCF is not a party, where it's a guardian seeking a right to adopt over the objection of a biological parent. Do you have any such cases?
I do not.
You have no cases in which a petition for adoption has been allowed over the objection of a biological parent without DCF's involvement?
So I do not have that prepared for today. I have been involved during my time of practice in guardianships where there are such contested hearings. And the practice in the lower court has been that which this judge did, which is to march through the same standards that the Department of Children and Families would have to meet, that there is a level of unfitness that requires a termination of the parental rights.
But you know of no reported appellate decision upholding such a termination?
No, Your Honor.
Great. Do you understand why someone might choose the guardianship route that was chosen by your client here, rather than the, whatever it's called, surrender or agreement for adoption, I don't know what the right phrase is, for what's sometimes used?
So to answer a question that you posed to Attorney Lopresti, you were absolutely correct that when the parties entered into this guardianship agreement back at the very beginning, simultaneously with that, they could have had the surrender executed, held the surrender for 6 months, and then presented the surrender, and that would have, although it would not have been effective until the court approved it, at least that document would have been in place.
Is the standard for approval higher or more difficult than a guardianship? That is, did they deliberately choose the guardianship route so they wouldn't have to go through whatever kind of vetting or approval is attendant upon a surrender and or approval of a surrogacy contract?
So as it relates to why they chose this route, it is actually in the record. There is the lower court judge cites this in one of the footnotes where biological mother and intended mother guardian are having a conversation about what the process is going to be, that there has to be a guardianship, and then the adoption follows therefrom. The simplest answer, Your Honor, is that nobody got real legal advice about how to go about this process prior to them actually embarking upon it. I believe the record also reflects the reason that a formal surrogacy was not entered was an issue of finances. There was some talk about that in the Facebook about why we aren't going with the traditional surrogacy piece because we can't afford it. So I'm just trying to figure out, I don't want us to make a mistake in this decision and do something that I don't know if this is the same or different from what Chief Justice Green was saying. I don't want us to bless a procedure that's no good, right? Absolutely.
And let me just say, it is obvious to me that the procedure your client and this mother used was no good. But but that's not to say that, I mean, it's tragic, terrible. I don't have words for it, case, but it has to be resolved for the child's good in a way that is appropriate. So I'm trying to figure out, can people enter a surrogacy contract to have a stranger have a baby for them with her own egg and some third-party sperm? Do we enforce those? Is any vetting of either the would-be adoptive mother or parent and or of the donor, is there anything in place in Massachusetts law that requires any of that? Or it's just the Wild West out there?
So, Your Honor, my understanding is that in a formal surrogacy contract, as in this case, if it proceeds, as I believe it will, into the formal adoption, there is a process, there is a home study, there is a colloquy. Even at the guardianship level, although it is true that any parent, biological parent, can give their child to anybody on the street, they stand before the court, and the court inquires as to the biological parent and the guardian, why is it that you believe that making this nomination is in the best interest of the child? What is it about the guardian that makes them fit to parent your child in your absence? And that
Was the mother asked that?
At the biological mother at the initial hearing?
Yes, at the guardianship hearing.
I would
Was
say
she asked
yes.
anything? Is there a transcript of that? Do we have that?
We do not have the transcript, but there is a colloquy, and in the initial guardianship, there is a finding that it is in, if I can get my hands on that initial piece, there absolutely was a colloquy, and the mother absolutely acknowledged, and I believe that's also in the transcripts at the trial, where both biological mother and guardian testified as to what occurred at that hearing when the initial judge entered what we call a permanent.
How can the mother know that it's any good for the child to go to this guardian in this case?
So that's where the issue came in, that this judge found that biological mother and biological father abandoned the child and were not acting in the child's best interest. Because at the end of the
Very confusing to me. The mother and father are being tagged with having recklessly or something given the child to your client because they know nothing about her. But you want your client to keep the child, although no one knows anything about it.
So, but the court did. The court took substantial evidence about how my client was parenting this child, how the child was doing.
No, I agree that that's an overstatement on my part.
I think we're going to need to hear from Counsel.
Yeah, let's do that.
Well over time.
Thank you very much. I apologize for taking extra.
It's quite all right. Attorney Parker, you have to take yourself off mute.
May it please the court, I represent the child in this case. I'd like to begin with refuting the Section 16L letter sent by the mother's counsel where she cites adoption of Adina as precedent because that case involved a particular prong of the 210 Section 3 statute involving substance abuse and domestic violence. And of course, the department has to show harm, that the taking cocaine once or twice a month or whatever, how often, is causing harm before they can remove the child and terminate parental rights. This case, the harm won't happen until, and if, and I hopefully won't ever happen, until a court orders the child away from the guardian. So that case has no precedent here relevance here whatsoever. There are a plethora of guardianship cases that find unfitness based on the child being with the guardian and doing well with the guardian. For example, in 338 Mass 635, the court, in a case in where an unwed mother left the baby with a doctor and said, "Doctor, you place this child for adoption." The court then changes her mind. It was informal, like this one. When a child is placed by its parent for adoption, the inevitable consequence will be that firm bonds of affection and confidence will rapidly arise on both sides. The damage to the child, who cannot understand what is happening from breaking these bonds, is something which even competent psychiatrists may be unable to predict. Such a breach should not be permitted lightly at the request of either of the natural parents who had their chance to take care of the child themselves and who themselves have created the unfortunate situation. The interests of the natural parents in such a case must be completely subordinated to the paramount interest of the child. And there are many other cases that are guardianship cases. And in fact, Section 512.
I'm sorry, that the language you were quoting is in adoption of a minor, 338 Mass 635?
338 Mass 635.
Okay.
And in fact, the statute, the guardianship statute, Section 512A provides for removal of a guardian on the ground that removal is in the best interest of the ward. There's no unfitness of the parent in the removal statute. However, in case law, the guardianship of Kelvin says that although it doesn't expressly mention parental unfitness, it's a highly relevant factor. Unfitness is a relative factor. It's not determinative. And
can I ask you though, there are two orders here, right? One is not returning the guardianship to the biological parents, but there's also a petition for adoption that's allowed without the consent of the parents. Do you agree that the standard for that is unfitness?
Well, there is unfitness.
No, I understand that. I'm asking though about, I hear what you're saying about best interest and a guardianship, but in general, we don't just allow adoption on a best interest standard unless the biological parents are unfit. Now, obviously this could all have been avoided had everybody done this right, and they didn't.
Well, maybe we don't have to go there, because if you look at General Laws, Chapter 210 in the state interventions, Section 3C9, the judge found severe or repetitive conduct of physically or emotionally abusive or neglectful nature by giving the child away to someone they only knew on Facebook, by failing to take any steps to enhance his health or welfare, not even checking to see how he was doing, physically and emotionally abandoning the child. The father placed the child at physical risk by throwing a brick through the guardian's window. The mother exposed the child to potential harm due to her Facebook postings. And there was a pattern of irresponsible decision-making. When they get the child back and they see the child's behavior issue, they might want to give the child back again.
Let me ask you this. How old is the child now?
Over 3.
Have you seen or spoken with the child?
Of course.
Recently?
In January, mid-January.
And is the child still in the placement with the guardian?
Yes, and he spontaneously said, "I love you" to the guardian while I was watching.
Okay, well, it's all outside the record, but I like to know that in a case like this, in the event that there's some dramatic change in circumstance. But all right, very good.
There are many guardianship cases in which they've said the kid should be adopted by the parent. First of all, I'll start with the surrogate parenting case. AZ versus BZ was a surrogate contract in which they said, as long as it contained the reasonable waiting period consistent with 210 section 2 of over 4 days to consent. And here the consent was, if you look at the facts, the consent wasn't just to the guardianship, it was to the adoption. It was always intended that that was just a way station. The mother said in the language that she posted that I will adopt. It was actually, I'll give you the child, it was conditioned on the adoption. Yeah, serious about the baby, you want to do an adoption, I would have a baby and do an adoption for you. I would have a baby and do an adoption for you. It was all conditioned. She would have the baby if you would do the adoption. That was always the agreement.
But it's not, this isn't, and I understand why you're saying the child's best interests are paramount and that it's not about legal formalities. And to some degree, that's the difficulty the various adults here have put us in, having to look at the legal formalities so that we don't do something foolish and have something like this happen again. But obviously the consequence shouldn't be on the back of the child. I'm just trying to figure out, it's not a surrogacy contract, right? There is inadequate, I don't know what the rules are for surrogacy contracts, but a Facebook back and forth presumably isn't a good enough way to enter a real surrogacy contract, is it?
Calls it a quasi. In her findings on page 20, and on page 24, she refers to it as an informal surrogacy contract.
What is our case law or statutory law say about informal surrogacy contracts?
They, in AZ, and in many of these guardianship cases have enforced them. And
AZ was a formal surrogacy requirement contract.
maybe, but there's a bunch of guardianship cases in which they've enforced them.
But we're talking about an adoption, not a guardianship.
Yes, they have said, there's one involving sisters where the child was with the sister a long time.
What's the, do you have a citation?
But I've got a bunch of cases. I would see this was.
Are they in your brief?
Yes, 343 Mass 292 is in my brief at page.
We will review the authorities in your brief, but again, we've reached the end of our time. This is a troubling and difficult case, but I appreciate the efforts you all have made to present it to us.
Yes, you've all done an excellent job of helping to inform us. It is a terrible case.
All right, that concludes the argument. The case is.
Are live and on the record.
That brings us to the sixth and final case on our list for argument today, case number 2019 P972, Nathan MARQUIS LEBARON and others versus Luis S. Spencer and others. You may begin.
Thank you, Your Honor. Jennifer Staples representing the defendants from the Department of Correction. May it please the court. Your Honors, we're here because the defendants are appealing several orders from the Worcester Superior Court concerning plaintiffs' claims which were brought exclusively under the Religious Land Use and Institutional Persons Act, otherwise known as RLUIPA. The claims brought by the plaintiffs involve two important areas. The first being their access to what they deem to be the Holy Diet. And the second is about their claim to access to an exclusive dedicated space at MCI Norfolk for their Messianic Jewish synagogue. All claims, as I stated, were brought exclusively under RLUIPA. And the first order I'd like to bring to the court's attention was actually issued by the court at the summary judgment stage. To begin with, at the summary judgment stage.
Before I have a procedural, do we have final judgments on these orders? The procedural posture of this case is difficult to follow.
Your Honor, that is being mild. In having lived through that, it's a very, very difficult procedural history. There was not official final judgment issued by the trial court. We actually asked for that, the defendants, several times. Nothing was ever issued, despite the fact that the court carried on with additional hearings post-trial. And in fact, the department brought a emergency motion to
then other than injunctive relief, how is this before us properly?
Strictly on injunctive relief, Your Honor.
All right.
That is all it is. It's access to their.
So the second paragraph of 231-118.
Correct. So at this point, Your Honor, I bring your attention to the first order that was issued by the trial judge at summary judgment concerning the Holy Diet. At the time of summary judgment, the Department of Correction was issuing two plaintiffs who are a religious group. They follow the Messianic Jewish faith loosely, but they also have their own personal tenets and their own personal practices. And at that time, they had requested access to what they deemed to be a holy diet. The trial court itself found it several times that this diet was not clearly defined. And if you look at the pleadings over the years of this case, it changed quite a bit.
What I see in the record is a declaratory judgment, so-called, entered by the chief judge of the church, the plaintiff. That lays out the contours of the so-called holy diet.
That's correct, Your Honor, but that was at the time of the filing, and it also changed and became more fluid as more filings came about.
Well, it seems clear to me. I mean, first of all, I should just say, I don't think it makes sense to call these personal views. The judge found them to be a religious exercise motivated by a sincerely held religious belief. So I think we have to start, unless that's clear error, we have to start with that. My understanding of the holy diet is that it has to do with fresh and unprocessed foods, including fresh or frozen kosher meat, but that a kosher diet is not in compliance with the holy diet. Is that not your understanding?
Well, that was plaintiff's argument. It is not my understanding based on the subsequent rulings of the court.
What is the judge's order that you're appealing from with respect to the Holy Diet?
Well, respectfully, Your Honor, it's difficult to pin that down. The court at summary judgment ordered the defendants to provide the Holy Diet as described by plaintiffs. Then there were subsequent rulings that occurred, at which time the court ordered that the kosher diet and a regular meal diet should be provided to both meals to each plaintiff at each.
And that's what you're doing, and that's what you all are doing now. You're providing them that choice. Is that right?
That order was changed again to an either or choice, and that is what we are doing at this time. So the court went.
And so that's the injunction you're following. So that must be the one you're appealing, right?
It is, Your Honor. We are appealing.
And you filed a notice of appeal from that order.
That was part of the notice of appeal that had been filed. There had been several filed in the trial court. Yes.
But after the order that modifies it to this either or within whatever it is, 30 or 60 days, I don't know what the rule is, you filed a notice of appeal. And that's the appeal, one part of what we're hearing.
Yes, Your Honor.
Okay, go ahead.
So that's where we stand with the Holy Diet. And it's the department's position that the court erred in awarding summary judgment to plaintiffs with regards to the Holy Diet, and in fact, not to defendants. The court.
Just to be clear, the order that entered on the Holy Diet entered on a procedural posture of summary judgment.
The first order entered on summary judgment. That's correct. And then,
but the foundational determination that the Holy Diet was an element of the particular religious practice that was protected was done on the basis of the summary judgment record.
Correct, and that was never changed. That's absolutely correct. From that time, though, at the time of the summary judgment, the court actually did a RLUIPA analysis, and indeed the court found that it was a religious tenet, and the denial of access to the Holy Diet was a substantial burden on the plaintiff's RLUIPA rights.
Okay, so then what's your objection, or what is the error here with the current order that they have to be given either one or the other diet at their choice? What is your objection?
The objection, Your Honor, is first of all, we want to be clear that there's a final judgment on the Holy Diet, and that's one aspect that the defendants are looking for. But second, and more importantly, is the defendants were always willing to provide the kosher diet. The fact that the order
kosher diet it is not a less restrictive alternative, as it does not meet the requirements of the Holy Diet. Now, it may be that you don't have to meet the requirements of the Holy Diet, but if your whole argument is you have a less restrictive alternative, and the court has found that a kosher diet is not adequate to meet the Holy Diet, at least not as well or as whatever as the current regime, isn't that a finding of fact?
I would suggest if that was the only finding, and if had the court not tweaked and changed the order multiple times, then we would be.
Why can't the court change the order as they learn more information or whatever? I don't understand the objection.
Because if
much of your objection is he said one thing, I think it's he, the judge, said one thing earlier and one thing earlier, one thing later. But so what? If it denied you the opportunity to argue something, then I understand why a change is no good. But if it didn't, I don't understand why you are saying we want to give the kosher diet. There's a finding that is not a less restrictive alternative. So I don't understand the basis for your objection. Now, if you say to me, we have a compelling interest in not offering them two diets, I guess we can talk about that.
Well, in fact, we do have a compelling argument not to offer two diets because the waste that is being produced.
Did you raise waste below?
We did. And that is why, and I will suggest to the court, that is why you saw multiple changes to the diet order. There was multiple hearings held.
Did you argue that what's going on now, I understand that going and getting fresh avocados or something, or pears, for some subset of a prison might be very burdensome.
Correct.
The judge seems to have thought that this was a pretty narrow way of approximating the needs of the plaintiffs. You already have kosher meals, you already have regular meals. did you object to having to provide a choice on the ground that that would be wasteful? Because that's what I didn't see below.
Your Honor, I do not believe from that order we proceeded with an appeal at that time. Quite frankly, because we were under the impression that this was the order to follow for now, that we were trying to.
I thought it was a temporary order myself. You're now saying there was a final judgment.
I would suggest, based on the last order from the court on the diet, which happened several months after the trial, where plaintiffs brought another motion, a contempt motion, asking for the original order to be implemented. The court specifically said that she found offering the kosher diet along with a choice to the regular line meal was the least restrictive means of meeting this burden, and therefore continued the order, but only continued the order, Your Honor, and while this, specifically, the court stated, while this case winds its way through the appellate process.
But my understanding is that the trial did not concern itself with the holy diet. The trial was about the dedicated worship space.
That's correct.
So that the record that we had for the establishment and then any subsequent adjustments to the holy diet was done first on summary judgment, and then in what appear to be a series of rather ad hoc reviews by the judge with the parties on the implementation of that initial order.
That's correct, and some of the changes were made without any evidence presented, and just meetings with the parties. With the court's permission, I can address the dedicated space issue.
Please.
Unless there's other. So with regard to the dedicated space, Your Honor, it is the defendant's position that, number one, we should have been awarded summary judgment at the time with regards to the dedicated space. But even after the trial, the court erred for several reasons. Number one,
can I just I have a question about that. If summary judgment is denied and the case proceeds to trial on the merits, you can't appeal the denial of the summary judgment.
The case is deerskin trading.
Okay. Well, in any event, we are appealing it from the trial court finding with regards to the space. And it's for several reasons and similar reasons. The court did the RLUIPA analysis, again, found that the denial to the space, it was a burden on the religious practice. But she also specifically found that the department had compelling interest for denying that space. That was not only allocation of resources, which are very scarce at MCI Norfolk, and there was plenty of evidence at the trial about that. But also, Your Honor, the fact that the court had also found at summary judgment that the department had a compelling interest in not allowing inmates to meet together and worship without a paid DOC employee or a volunteer.
Okay, but this seems like this almost willful denial of what the judge says in the order. The judge couldn't be clearer. You have to allow these people to do whatever you allow the other ones with dedicated space to do, because that demonstrates what is the least restrictive alternative. If you're able to do it for the others, do it for them. If they do or don't have whatever it is they do, and you keep insisting, contrary to the text of the order, that what's being required is prisoner-led worship. And I just don't see that in the order, unless you allow prisoner-led worship by Protestants and Catholics, Jews, Hindus, and Muslims.
Well, Your Honor, that goes into the argument about the fact that the court used an equal protection.
It's not equal protection. It's just evidence of what you can do consistent with your mission of security at the prison. You obviously are able to have some religious groups have dedicated space and do whatever it is they do. And all the judge is saying, if I'm not misreading it, is, and so do that for the Messianic Jews too. And instead, what DOC has done is, oh, here's the dedicated space, the door is locked. And for not insanely, it seems to me, the judge was apparently annoyed by that decision.
Well, Your Honor, with all due respect, she did find that we had a compelling interest not to allow them.
At the end of the day, I don't know when she found what, but there's an order that says treat them the way you treat everybody else, since that seems to be okay with you. And I gather until the final order entered, you weren't.
Well, we weren't, Your Honor, because there's evidence that would have been submitted at trial that these groups are not similarly situated to
I thought there was a trial.
Yes, but the trial was
It was a
not on equal
trial.
protection.
It was not an equal protection trial. It
It's
was a
not
relu-
equal. It is not equal protection. It is a question, it seems to me, maybe I'm mistaken. It's a question of what you can and can't do, and telling us, you put in the brief, these people aren't vetted. The hell is that? I don't know what that is. Then vet them. I mean, I don't get it.
Well, Your Honor, what vetting means is, does this group cause any kind of concern with regard to security and safety?
Do they?
Yes, they do.
More than the other religious groups.
Yes, Your
Why?
Honor. There's a filing in August of 2020 where the department, being called in again by the trial judge on a motion filed, alerted the court to the fact that Mr. Mallory, who is represented by counsel, life was threatened by another plaintiff. And in fact, there was a plan to cause him harm in that very room.
There's nothing like that happens with respect to prisoners in the other religious rooms.
It has not caused enough concern that those groups could not meet. And, Your Honor, those groups' evidence would have come in had this been an equal protection case. Those groups are also led by full-time employees who are present at the facility and can oversee them on a regular basis.
So DOC hires people full-time to be in those spaces.
That has been a position that has been available at MCI Norfolk, and we do, because of the sizes of the group. That's correct.
Because of the sizes of the group.
There is correct, and they are positions that have been available at MCI Norfolk for an extended period of time.
How big is this group? Is it in the record?
Well, that's changing. At the time, it went from something of maybe about 30 down. I think right now we're looking at very few of them. Some people are part of the group, but they only to the extent that they receive the diet. They do not participate in the corporate.
How many Jews are there in the Jewish group?
I don't have the answer to that, but I do know they're large. It's a larger group.
More than 30?
Is my guess, yes.
You think there are more than 30 in the Jewish group at MCI Norfolk?
If we're not taking in COVID, Your Honor, I'm sorry, there were releases and I'm not sure of the levels.
No,
But I can tell you that there are those traditional religious groups are bigger in number and have remained bigger in number. We also have at MCI Norfolk a number of very small religious groups that are recognized and including Rastafarians. We have Wiccans, we have Buddhists.
But apparently it does not burden their religious practice to not have a dedicated space.
They have not asked for that yet. That's correct.
Thank you.
Thank you.
Time is concluded. Attorney Goldblatt.
I want to be able to respond to some of what counsel argued. I'm not sure of some of the record citations to it. I'm aware that the number of people in this group has dramatically fallen off. And I'm also aware in the lower court that there were many, many claims of retaliation against this particular group, which is not what this trial is about. But I think the evidence that from when this conflict started, there were more than 30. I know there's a list. This is part of the record because it's in the certificate of service of my opening brief. There were so many that I was having trouble keeping up with all the people who had joined the group. It was certainly more than 30. It might have fallen off considerably. And I don't think that the amount of conflict that the DOC has been causing about this would open an equal protection claim, which is not what this lawsuit is. But that would certainly be, I think, their next step if the DOC's argument was, well, we've convinced everybody not to be in this church anymore, so we don't need to give them a dedicated space. As to just the pure legal issues, it sounds like the court has a handle on it. If there are any questions.
Well, let me start by asking you for the, I guess, what would I call it? The church law, the ecclesiastical law foundation for the Holy Diet.
The Holy Diet was based on the summary judgment documents that were filed in the record.
What I saw in the summary judgment record was a declaratory, as I referred to before, a declaratory judgment authored by the by the lead plaintiff in his self-appointed role as the chief judge. Is there any external support apart from the lead plaintiff's declaration for an independent ecclesiastical foundation for the Holy Diet as a central tenet of Messianic Judaism?
I don't know what you mean by external. You mean external to this
I mean
particular?
by somebody other than the lead plaintiff's say so. Is there a body of ecclesiastical law describing and defining Messianic Judaism? Is there a body? Okay, none.
That is not in the record, and
Any
this is
kind?
my understanding of from the record of how this works is that this is a church that was formed as a subset of Messianic Judaism.
I understand that, but if I want to form my own church and declare that I will eat only, let's say, filet mignon and lobster on alternating days, yeah, I can't declare that and have it be given credence by an external authority without my ability to root that in some legitimate recognized external religious practice.
Again, I'm not sure what you mean by external.
Well, okay.
It's tradition for Judaism to perform
somebody
worship
other than me,
of
some basic ecclesiastical foundation other than my say so that this is my religion and this is what I'm saying.
Wait. Maybe I'm
I think we have
mistaken.
different ideas about what religion. The way Judaism works is that groups of 10 or more people form, they create a minyan, they interpret scripture, they write documents about it, they study it together, and then those documents become the tradition of that particular minyan.
That's not the question. Isn't what is Judaism, I don't think, or even what is Messianic Judaism. Isn't the only question for a court whether this is a bona fide religion? And didn't the judge, I don't hear, I mean, lurking in DOC's filings is the sense that it's not a legitimate religion. I understand that the court found that this version of Messianic Judaism, let's even call it the LeBaron version of Messianic Judaism, is a sincerely held religious belief, and that the Holy Diet, for example, is a religious exercise motivated by that belief. Now, I think that must be a mixed question of fact and law, and I guess I understand Chief Judge Green to be saying some things are going to be less believable than others.
Well, but let me also just point out that my question goes in part to the fact that in my experience, judges don't make findings on summary judgment.
Not appropriately.
Well, unless they're not disputed, they're not findings, but if the facts are undisputed, then they're undisputed. I didn't read the brief of maybe you can tell me, Attorney Goldblatt, I didn't read DOC's brief to quarrel with the finding of sincerely held religious belief.
No, the brief was a little bit confusing because there was none, the summary judgment materials weren't included in the record appendix. So there was no mention of what the basis of the judge's conclusion was or whether it was wrong. They just argued, as you said, it's sort of sub rosa, that it's not sincere, or that it is, right, as Justice Green suggested, just a way to get a filet mignon every now and then, which I don't think the record
say
reflects.
that the holy, excuse me, they do say that the Holy Diet is just a list of preferred things they'd like to eat. That clearly implies that it's not a bona fide, they believe that it's not a bona fide religious component.
I thought preferred was
Messianic Judaism.
I thought the preferred word was used by DOC. I have to say,
that's what I'm saying.
Yeah.
Oh, yeah, I see. Yes. Oh, I see. So you're saying
so there is the question of whether that is in fact a bona fide religious.
Maybe lurking here.
For the difficulty I have is seeing how that is established as matter of law on the summary judgment record that we have.
What I have is the record that we have that's primarily directed at this issue of whether this is sincere is basically a scriptural study by the leader of the church, where he pulls out all these scriptural things from the Bible and explains what they mean to him, and how the people in the church, how he thinks they should be interpreted in terms of governing how they keep their bodies. It's part of the purity,
Right,
the sort of Leviticus purity. So
but the
he has,
question
that's
of whether that is a sincerely held religious belief remains a question of credibility and one of fact, right?
But it's certainly not an issue of fact whether this is just a list of food preferences, because lists of food preferences don't include interpretations of scripture. That's not how people express food preferences. Like when I go to a restaurant, I don't quote the Bible. I just tell them what I want to eat. But when I'm studying the Bible or purity, then I discuss how they work together. So
right,
the
but if you're not
document
in a restaurant, but in a setting where, in order to get what you want, you need to frame it as a matter of religious freedom, you might quote scripture in order to achieve that objective.
there's no evidence that that's what was going on, and
Is
there's
there an
no
agreed upon statement of facts?
No.
Oh, well.
And there's no evidence that's what was going on. And the DOC didn't put any evidence in that what was going on. The only record comes from the people in the church, and the DOC have put nothing in the record to suggest that these people are not sincere, except to say, they're not sincere. Look at them, they're prisoners. They can only get what they want by being religious.
How is it any less functionary than claiming they are sincere?
Excuse me?
How is it any less functionary in a summary judgment setting than claims that they are sincere? It's a dispute of a material fact.
The court found that there was no evidence that they weren't.
And that's the problem. That's the problem. Okay, just stop. That's the problem. Judges don't make findings on summary judgment. This judge has a history of doing that.
I don't know anything about this judge, but I will say this. You have to dispute a fact for it to be a disputed fact.
There's no evidence that these people were insincere. Classic evidence of insincerity is, I saw them sneaking chocolate bars. They eat processed food, right? Like that's the kind of way that we have their commissary records. We know everything they order. We're going to pull up all these people and show that they're not actually following this diet. None of that happens.
The fact that they may not be fastidious in their observance is different from whether it's a sincerely held belief. I mean, there are probably Jews who sneak bacon and Catholics who used to eat meat on Fridays.
I'm just giving an example of something somebody could have said that would at least have called into question that these people are extremely sincere.
That's not the nature of the question that would call it into question. The real question is whether there is something more than his say so.
Do we have the filings of DOC on summary judgment, and they raise sincerity?
Yes.
I'll have to look.
Can I ask a question about recusal before we run out of time? I think what's in play here is more than a judge's right to read the newspaper. Whereas I don't participate on Twitter myself, I think it's pretty well understood that when you retweet something, that you're endorsing what you're retweeting. With that assumption, and coupled with an article that is critical of a party and their practices at the prison, a party that's appearing before this judge, although the article is not about this case, why doesn't that call into question the judge's partiality towards MCI Norfolk in these circumstances?
That is a great question. And I think this is a super interesting issue. So I was hoping we would get to it. So here's my take on that. It's not something that's been litigated yet, but I've thought a lot about it. So the issue here is, was this article, which is a news article, which lists a series of facts, intrinsically critical? Because certainly if I quote somebody and I say, did you know that, Anne said this thing, I think Anne's a liar. Am I endorsing the thing Anne said? Probably not. right?
Are you
So
familiar
the
with
question
the,
of who's endorsing, the question of what,
are you familiar with the ethics opinion that the Committee on Judicial Ethics issued in accordance, in response to a request by an individual judge?
yes, that's you're talking about the one that was cited here.
Right.
Yes.
And within that opinion, which released before the trial of this case, the committee admonished the judge who requested and all of the rest of us the following: you must not retweet or link to case reports from persons or organizations with legal opinions that are clearly on one side of contested and highly charged legal issues. That's consistent with what you've just said.
Right.
Reports even by, and these following two words are in quotes, mainstream media should be avoided, as such reports may contain commentary or reaction favoring one point of view. Now this, whether you view the newspaper article on balance and on the whole as advocating one point of view or another, it in fact does contain commentary or reaction favoring one point of view. It is in direct contravention of the Committee on Judicial Ethics opinion, specifically targeting the appropriate use of Twitter. And it was on the eve of trial involving a party to a case over which the judge was presiding. Is that not troublesome?
No, and here's why. Because it wasn't just when the opinion says quoting an opinion that is critical. That's different than quoting all opinions that are mutually contradictory. So yes, and I think what we're thinking about
I'll
here
read you
is
the sentence again. Reports even by mainstream media should be avoided, as such reports may contain commentary or reaction favoring one point of view.
But isn't that by the media?
that is my interpretation of it, that it is that if the media itself is endorsing one point of view or the other, that is something that you need to be concerned about. In this case, the only view that the media that was endorsed by the media was that this is a dispute that is happening, or that these are facts that are occurring. So I don't think
I'm sorry, there was more than that to the article, and granted,
whoops,
we've only you disappeared. There's more to the article than that. They're highly critical of someone being put in isolation for the mere sin of trying to distribute water at a prison that has water that looks like black tea.
A few people were critical. They were quoted. Frankly, they were pretty robustly contradicted by a really much more credible statement from.
Still involves a party who is appearing before the judge in a matter of days.
And the opinion was not this is the issue I think that really matters here, and whether we interpret this to mean that if a newspaper article quotes somebody who was critical, is that newspaper article now verboten and no judge can retweet it?
It's the problem. It's not what happened in the article. It's that the judge endorses it by retweeting it.
She endorses the article. She doesn't endorse all the quotations in the article. And
how do we know
here,
that? How do we know that?
Because she can't possibly endorse all the quotations in the article because they are mutually contradictory. And there is
the second part of the standard in Lena is objective. Would it reasonably appear from an objective person that she's not being impartial? I enjoy very much your argument on the matter, but that's what it is. It doesn't address the objective standard.
I suggest no, it doesn't. When you have an article that says this is a thing that happened in the prison, this is what the people objected to, and this is how the prison explains it, and that's the article. The idea that because somebody has publicly represented that some people were unhappy about it, and then publicly explained why that was unavoidable, with no response from the other people, it's that the prison is being disingenuous when they say that there's no response that, oh, they're lying.
I understand.
It's just, that's what's going on in the prison.
We've
There were
reached the end of our time. I think we're gonna have to leave it there. Thank you both for your argument, and the case is submitted.
Thank
That
you.
concludes our
Thank you.
session.